Yeah, there we go. Well, good evening, everyone. My name is Sheila Lynch. I'm with Denver Regional Council of Governments, and I am joined today by Chris Valdez, who is also with DRCOG. And we are just excited to be here today. Miranda reached out to us many weeks ago asking if we might do a training. And so we put together some information and hopefully it'll be very interactive. We hope that we can get some discussions going. I will preface, sure, thank you. We have some props to use during the training to make it even more fun. I will preface it by saying Chris and I, both of us are trained as planners, as urban planners. We both have experience with local government. I spent some time in public health, working as a planner in public health. And Chris has also been in private consulting. Neither of us are attorneys. So we are so glad that Jennifer is here with us tonight, because if there are any specific legal questions, we're certainly going to turn to her to help us, to fill us in on what's the best route on some of your observations. So I will pass it on to Chris, who's going to get us started, but we're essentially over tonight, we're going to cover kind of three main areas. We thought we'd start with some really planning intro information, because it lays the groundwork for two specific topics that we'd like to cover that was at the request of the Planning Commission, is quasi-judicial review and then ex parte communications. So that's our plan for this evening. I will pass it off to Chris and she'll get us started with our Planning 101.
Thank you, Sheila. Oh, that's perfect. Okay, so if we could go with the next slide and we'll get started. So, I don't know, we can't quite all see that, but yeah. So first of all, I kind of wanted to go, that's as good as it's gonna get? Okay. All right, no, that's okay. So what we want to go over is, like, why do communities plan? Why is it so important? And according to the American Planning Association, the goal of planning is to maximize the health, safety, and economic well-being of all people. Now, what we did is also took a look at your code, and according to Chapter 16 zoning, why we plan here is the protection of the public health, safety, comfort, convenience, order, prosperity, and welfare. And that's taken directly out of the municipal code. So essentially what planning does is we're trying to help this or protect health, safety, and welfare of the community, but also balancing that with private property rights. So that's kind of what we're going to look at for this evening. And if you do the next slide, we actually have our first question of the night for you guys. We want to know, what does it mean to you to really have the maximum benefit of health, safety, and economic well-being of the community? What does that look like to the Planning Commission? And so we just kind of want to do a little popcorn. Somebody shout out. What makes planning important to the community for you guys?
Well, I think it's a great opportunity to shape how our town is going to grow. It's the way that we can, keep types of, buildings and corporations and things that we don't think are a good fit in our community out through zoning and planning and our master plan. And it allows us to try and plan towards the benefit of the greater good of the community. And although there might be a couple of people that are in favor of that, we try to keep the greater good of the entire community. That's my interpretation.
Thank you. Anybody else?
It's important to help with resource allocation of taxes that are collected, to how to distribute things, road maintenance, a bunch of other things, but also to bring the community together, like the community center, to have funds and people to help gather and to build a true community, as opposed to just a place where a bunch of people happen to live.
Nice. Anybody else?
Yeah, I would just say too, like ultimately it's taking the spirit of the community and the place that we live and combining that with like the on paper, visions and plans that have been a long time in the past. Logically adapting those as needed, but whether we're a little town mountain like we are, or you're a town in the Midwest, we've got very different resources, like you said, you've got spirit and all of the stuff to manage growth and what they currently have and different things.
Awesome.
There, but
Gotcha.
but we're not.
Anybody else? It's
Sheila, it's Miranda really quick. For those of you in the room, can you be sure to unmute yourself so that people online can hear you?
okay. Yeah.
Hi, Miranda.
Hello.
So I'll try. The actualize, I read that, what does it mean to maximize health, safety, and economic well-being of all people? I think that's a large mission, and we have, as it was mentioned, we have many different things that we have to do that. But then what is planning? Then, to me, then the planning and the planning part of it and the planning ordinance, chapter 16, it started 100 years ago of giving a community consistency so people would know what the community would be, where certain activities would be, where your residentials were. So it was a way to actually dividing up the town or giving everybody expectations of what their town would be.
Mhm.
Yeah, I would just say manage expectations.
Awesome. Thank you. Okay, we could go to the next slide. All right, so what we're kind of going to do is go over kind of broad brush what planning is, and then kind of get down into the nitty gritty and then talk about the quasi judicial and do our fun little exercise. But really, planning is the process of what you want your community to look like in the future. It could be 5 years, 10 years, 15, 20 years, but it's really looking about as a whole, what do you, as Planning Commission, as well as other community members, want your town to look like in the future? So that's really the goal of planning, in addition to what we said on that first slide. But it's about creating that vision and getting the community invested in that vision. Next slide. So how do we go about planning? Well, actually in 1974, the Local Government Land Use Control Act gave communities permission to have local control. Essentially, it was no longer a state issue. You got the chance to say, this is what we want to happen in the community, and these are the rules and regulations we are creating in order to create our community. And Michael, as you said, it's not just people living here, it's creating that community, and that's what planning does to help people, is bring that community together. So if we have the next slide, please. So Section 104 of that 1974 Land Use Act really gave regulatory powers to communities. And I'm going to go ahead and read some of these. But regulating development and activities in hazardous areas. We don't want people to build where they could get hurt. And obviously we have issues like wildfire in the West. Personal note, I've been pre-evac twice for wildfire where I live. So, I mean, it's, even though we build in valleys or away from and do wildfire mitigation, but we still want to do the best that we can and not put people in hazardous areas like avalanche or landslide where we know those are mapped. And then really protecting lands from activities which would cause immediate or foreseeable material danger to significant wildlife habitat and would endanger a wildlife species. And that's where the community works with Colorado Parks and Wildlife to make sure wildlife corridors are maintained, that we're not cutting them off from winter range and summer range and things like that, but really making sure that those land use regulations and that master plan incorporate wildlife and the natural environment. And then C is preserving areas of historical and archaeological importance. We want to maintain that heritage throughout the state of Colorado, and regulating with respect to the establishment of roads on public lands administered by the federal government. So we don't want roads just like willy-nilly accessing our public lands. We do want to be able to know the environmental impacts of those, and this act gave communities that ability. In the next slide. And then E is regulating the location of activities and developments which may result in significant changes in population density. And so what that's saying is we want to make sure that we have the services available for the population that's projected. That's working with the state demographer office, that's working with the census, making sure we have the services to serve the community well, and that we aren't underserving, but we also aren't overserving. I know that's a tricky, fuzzy crystal ball that sometimes we need to look at, but doing the best we can. And then F is providing for phased development of services and facilities. So that's making sure development is in keeping with those utilities, those roads, those maintenance, public services, things that the community needs in order to thrive. We want to make sure we're not outpacing the availability of those services. And then G is regulating the use of land on the basis of impact thereof on the community or surrounding areas. We want to make sure that the impact from any future development is mitigated, not only within the community, but on the surrounding areas. We want to make sure that those areas are protected, but also that private property rights are preserved. And otherwise planning for and regulating the use of land so as to provide planned and orderly use of land and protection in manner consistent with constitutional rights. So that's getting into those private property rights, making sure that there's not something called a takings, and your attorney can go into depth on that, but making sure that we give people reasonable use of the property, but still maintaining those resources on that property to make sure we're not creating any hazards. Next slide, please. Do you have a question?
Did you want to have input as we go, or do you want to kind of?
You can ask questions as we go. I should have said that. Yeah.
Could you give us an example of what overserving your community would look like?
So that, for an example, let's say you put in streets, streetlights, utilities, and then the subdivision doesn't come. So we, in planning world, we kind of call those zombie subdivisions, where then you've outlaid all this money to put in utilities, and then you have to service it, maintain it, but you're not getting any tax revenue because there's nobody really using the land.
Thank you.
Mm-hmm. Any other questions so far? Okay. So next slide, right? Yep. Yeah, so next slide. Okay, so this is that umbrella. So the comprehensive plan is kind of the overall vision for the community. And then we've got land development regulations or zoning and subdivision that essentially implement that community vision in the comprehensive plan. And then the development applications should reflect, I say should reflect the land development regulations and the vision within that comprehensive plan. So we're going to talk about those three elements in a little more detail. So next slide, please. So what is that comprehensive plan? As I kind of mentioned earlier, it's that vision for 5, 10, 15, even 20 years down the road. It's a roadmap for the future. It's really shaping policy decisions from the Planning Commission. Is this what you want here on this piece of property? And guiding those land use decisions. It informs investments. Do we want this to be part of a capital improvement project? I don't know. Let's look at the comprehensive plan. Let's see if the land use regulations support that vision. So making sure that that comprehensive plan doesn't just sit on a shelf and collect dust. It's actually being used in land use decisions and creating policies, budgets, things of that nature. Next slide, please. So why is the comprehensive plan so important to Planning Commission? In the state of Colorado, it is planning commissions that adopt comprehensive plans. So It is up to you guys to shape the community and making sure that that vision is implemented with community input. So you're the reviewing authority. So when a project comes in, you're the experts on the comprehensive plan and making sure that that comprehensive plan is honored throughout the process. Now, I'm not saying like once you adopt a comprehensive plan, that is it. It's a living document and needs to change based on economic conditions, development conditions. Things change over time. Probably no one could have predicted a global pandemic and the implications from a global pandemic 3 years ago. But you're the reviewing, go ahead.
I just want to let the public know that we're doing training until 8 o'clock and the actual planning commission meeting does not start until then, just in case. Planning commission, but we're just doing training until 8 o'clock. And then the actual items that I think you might be here to talk on will start not until 8. Yes. I just didn't want you to sit for another hour and a half. Thank you. Please continue, Sheila.
Right, yep. You could learn something. Planning's important. When I tell people I'm a land use planner, they're like, what is that? Okay, so state statutes require each municipality to have a comprehensive plan. So in order to get grants or funding, things of that nature, you need to have a comprehensive plan that details out what you want the community to look like in the future. You need actionable steps, objectives, strategies, things of that nature to make sure it's implementable. Because like I said, the last thing you want is a comprehensive plan that sits on the shelf and collects dust and isn't applicable to your community. It is an advisory document per state statute, but you can codify it, which means you adopt it as a standard into your land use regulations or land development code. You could say this project has to be in substantial conformance or in compliance with the comprehensive plan. That's something that you can do. Next slide. Which we do?
Yes.
Okay. I haven't read.
You do, there are legal issues with that
Mhm.
in that, for example, I think in the SRU review process, and I'm pulling up the code here just quickly. But one of the issues is your comprehensive plan specific enough to give a property owner knowledge and notice of the specific requirements. So you kind of need to balance that with the language, the criteria, for example, for an SRU application, and the standard is consistent with the comprehensive plan.
That term comes up. That's always been used kind of generically, and we have statements pro.
Yes, I mean, you can show, in many cases, you can show consistent is for the applicant, consistent is maybe for the neighboring property owners. So that can be difficult in terms of, more subjective than an objective standard.
Saying how we're looking for going forward with a comprehensive plan here in the next coming months. Can we talk about this just a little bit?
Yeah.
So we are the reviewing authority. What role is the BOT? The Board of Trustees?
Well,
Maybe, just give us a little.
I mean, I would imagine, it's going to be a process. And I would say that Chris and Sheila could walk you through that process, but it's going to be a multiple step process in terms of getting community input. What does the community want? You probably would have work sessions, maybe with the Planning Commission and the Board of Trustees. But it is, a multiple step process in defining what the goals are for the community, what your vision is for the community, and then all of that would be put into the comprehensive plan. I mean, Nederland would work with, probably hire a planning group to help them through this planning process. And then the next final step might be to implement, and I think this is where they're going, is implement the comprehensive plan into your zoning code.
Okay,
When you say that though, you're saying the Board of Trustees would codify it into the code then?
No, it's adopted at the implementing, yes,
Yeah.
is the process of codifying it into the code. And what that means is that, you know, if you're talking about the central business district and what you want for the central business district, it means taking your plan that is in your comprehensive plan and putting that into actual zoning code regulations. So what are your setbacks? What are your heights limits? What are your uses that you want to allow in the central business district? So that's how it's implemented then into your code. And I think we're jumping ahead a little bit.
Okay.
well, no, that's
We
fine,
getting
but you are the adopters. I just, you know, I've gone through this, but I've actually, after all these years, I still need a little clarity. Because I don't know that we actually had that in the last three. I mean, I've worked on 3 of them since 1987. So when it comes to just a small argument about one thing or another, or about, you know, just one little question, you know, if we can't, quite often, you know, we got into stuff that was, you know, borderline arguments, but just say, so if we're the adopters, does the 7 or 8, the 9 planners, are they in the end have to vote to say, you know, if there was one small little paragraph that we were arguing about the future, would the planners be the ones that should actually have a vote to say, this is the way it should be written?
Wanna go
I,
ahead?
I
I was
think,
gonna
I
say, are
think
you
what Roger is trying to ask is, right now, we're not the person who votes and finalizes it. Then it could be changed at the BOT level. The work that we do, then the BOT, our Board of Trustees, are going to be the ones that vote and are the final say. And I think that what you're asking is that if we're the adopters, do we get a vote in that?
Yeah, this is totally, we make motions to recommend, but I'm aware of the planning commission is the purview of, excuse me, the comprehensive plan is purview of the planning commission.
Mhm.
So if it, you know, came down to, you know, just, I mean, you don't really need a hypothetical, but we certainly had certain things, arguments, discussions about, I mean, the biggest one, example was 10 years ago, was about sustainability. And there was an entire community meeting and arguing about whether we should use the egg scenario or a three-legged stool as a scenario. And it got pretty volatile and pretty bad. So my question is, really, in the end, that was never something I ever thought about in all these times, was that in the end, if we, you know, push comes to shove, you can't decide as a community what 7 people should decide. So my
So-
question is the planning commission or the board of trustees?
So I'm gonna say it's twofold. So you should have a planning firm that can facilitate that discussion, first of all, so it doesn't get
Absolutely.
volatile. I've written a couple of comprehensive plans, more than a couple, and you don't ever want it to get to a shouting match. So that's like that's a first red flag of what you said. But it's about creating that consensus, and you want to make sure everyone is somewhat happy. So, you know, I used to joke when I was a public planner, if everybody was mad at me, then I was doing my job, because that means everybody had to give a little. So it's about creating that middle ground and then being able to implement that middle ground. But while you guys adopt the comprehensive plan, the final decision makers on a development project is the Board of Trustees. So you adopt the comprehensive plan. However, I have worked in jurisdictions where also the Board of Trustees adopts the comprehensive plan once it's adopted by the Planning Commission. And then after that, you're more of a referral recommending body to the Board of Trustees.
Absolutely.
Okay.
Well, I think I got an answer from you.
Okay.
And the additional layer on that
Mhm.
too is, think about it, that the the Board of Trustees is adopting your ordinances.
Mhm.
And so if there's a piece of the comprehensive plan where there might not be agreement and consensus, then maybe the Board of Trustees doesn't agree to to
Okay.
codify that into your zoning ordinance.
Well, fine. No, I mean, I think we're a very small thing. Another example of what, I'm kind of bringing this up because we have some, people are good members here. Another example is that we've always, worked to increase the group and had citizens from a group come in and join in. 20 years ago plus, that we even had people from not a large group, but 4 or 5, which, it makes the group much bigger, that weren't even town residents.
Mhm.
They felt that this is our town too, we work here. So, but then it's a fine line between then taking over the process.
Mhm.
When you open up to 20, you have a group of 20. Now, it can get to be that way. So that's again, another example of
Mhm.
who in the end is the adopters. So they can help me out. But
Yeah.
that's something I just wanted to talk about and express to my fellow commissioners. That it, certain subjects, certain issues can get pretty volatile.
Mhm. Absolutely.
And it's volatile is not the right, it's near and dear to people's heart and their reasoning or how they feel about, their town.
Right. And to steal a line from Parks and Recreation, people care very loudly.
Sure.
And so when that, passion's ignited, sometimes tempers flare, but it's about having some great facilitation during those community discussions.
Right.
So, and I have found when I was working in the private sector that if you made those community engagement sessions fun somehow, some way, it diffused the tension a lot. So,
In the end, whether it was an eggshell or a 3-legged stool, it really didn't make a whole lot of difference. But I have spent hours discussing what is a small mountain community. I mean, really, literally hours.
And as you said, it's near and dear to people's hearts. So
Yeah.
they're willing to put that time in to discuss it at length. We're going to get to another slide later in this session talking about legislative process, and comprehensive plan process is a legislative process. And one of the things that as planning commission you could think about is that part of your role is helping to map out what will be the process for compiling the comprehensive plan, meaning how many public meetings will you have? How will you advertise for those and that kind of thing? So you will have a say in helping to design the process. So hopefully working with a consultant, you can design a process that hopefully people feel heard, and you can move forward, as Chris was describing, in a consensus model or some decision-making model so that you can get through the process as well.
Can I just add something or ask you to just touch on a matter really quickly, and that is related to the comprehensive plan. How would the 3-mile plan fit in? And I just bring this up just to give your perspective, because later on in the evening, the Planning Commission is going to be discussing a 3-mile plan. So I think it might be helpful for them to hear from you those thoughts.
yeah, so one of the components of a comprehensive plan that's required by state statute is a 3-mile plan for jurisdictions, unless you're a county. But for towns and municipalities, you need a 3-mile plan in order to get any annexation abilities. So that 3-mile plan is looking out, where are you going to put your utilities? What could that possible future land use be? So that's where your future land use map comes into play in a comprehensive plan. What do you want that to look like? Do you want it to annex it in? It's going to be commercial. What's going to be in that annexation agreement when you bring it into the town? What are you going to negotiate? The more you can, a lot of communities just, draw the 3-mile line around their town boundaries and they call it good, and they're really warm and fuzzy and mom and apple pie in the comprehensive plan. But actually, the more direction you can give on those immediate properties adjacent to your boundaries, the easier it's going to be to make that decision in the future. So I will tell you, the more detailed you get, the harder it is to get consensus. but your future self will thank you when that planning file comes in the door for annexation. So, does that answer?
It does.
Yeah.
And Netherland might be a little bit unique in that, and I don't know that this is a definitive answer, but there is a strong push not to annex. And so for that reason, the 3 Mile Plan might not have a lot of definition.
Is is that in the, I don't know if you know the code off the top of your head, 3112-105? Is that right?
So it's either 30 or 31.
30 or
It's
31?
it's in 31.
Okay.
Yeah, it's in the Annexation Act.
And I just want to clarify, I heard, so the 3 Mile Plan should be in part of the comprehensive plan, which we failed to actually do 10 years ago. I mean, we did a 3 Mile Plan, but we did not do a 3 Mile.
And it can be part of the comprehensive plan, but doesn't have to
It
be.
doesn't have to be okay.
Yes, you can have a separate standalone document that is your 3
Well,
Mile
I
Plan.
would assume. both,
Yeah.
but Okay.
I will say that it depends on where you get your funding though from. If you get funding that ties it to recreation and tourism and ties it to 3 Mile Plan, then you do have to include it in your comprehensive plan. But if you're self-funding it, then you don't necessarily have to put it in your comprehensive plan. But if you get grants to do your comprehensive plan, there are normally strings or expectations tied to that grant of what you have to include within that comprehensive plan. So.
And is that something that we typically, it can be a dual track process? They're working on those at the same time.
Mhm.
If we were able to hire an outside firm to help us with something like that?
Right.
Yeah.
Mhm.
Thank you.
Yeah, the other, well, I should come very quickly, the other issue that, like Jennifer mentioned, is that with our 3 Mile Plan, we, compared to all the other towns down below, we don't have a neighboring town, challenging and pushing and talking. So that was the biggest thing. Same thing with our agreement, IGA with the county. Well, we were unique because
Mhm.
Ward was going to come in and start annexing the property next door to us. So,
Right.
so that makes Netherland unique, that the demand on the town
Mhm.
is just the neighbor, and what do we really want for annexation? Not demand, oh, if we don't do it, the other town will.
Right. Yeah, where I've seen it is towns fighting over commercial.
Yes.
Yeah, they're cherry picking the commercial properties and things for tax revenue, things like that. So, any other questions before we move on to zoning? Okay, so kind of what is zoning? So it sounds like you're all very well educated in what zoning is, but really it's local government acts, legislative capacity that Sheila's going to talk about in a little bit, when it initially enacts a zoning ordinance or regulation. So it's that legislative action that says, this is the zoning ordinance, this is what you have to comply with when you come in with a land use application. And it's the division of areas into zones or districts to facilitate regulation of land uses, buildings, and other improvements. So it's saying, this is appropriate on this piece of property, this is not appropriate on this other piece of property. However, on this piece of property, we're going to allow mixed use of residential and commercial. So it's just taking that future land use map from your comprehensive plan and then translating it into zoning designations, which are legislative. So next slide, please. Once again, kind of what's zoning? It's the fundamental planning tool in the planner's toolbox. So it's what most local governments do to balance the interests of public welfare and those private landowner rights. So making sure that the private landowner knows what to expect. It's that consistency that we talked about earlier. Knowing what is expected on that piece of property should be outlined in that zoning ordinance. And it's generally deemed to be matters of local concern rather than matters of statewide interest. That kind of comes out of that 1974 Act, that Land Use Act, that gave powers to local jurisdictions. So the state hopefully is not going to get involved. And well, hopefully. Kind of, okay. We'll see. Okay. I might have to lob that one over to your attorney. All right. So next slide, please. So really, zoning has been around for a really long time, and it's supported by the Supreme Court. So the city of New York was the first jurisdiction to have a comprehensive zoning ordinance, and it was in 1916. So it was legally challenged, like all good planning cases. It was legally challenged in the Supreme Court in Euclid versus Ambler Realty in 1926. And what the Supreme Court says is that zoning was a valid act of the local government, that you could separate uses. Because in Euclid versus Ambler Realty, what we had were tenement houses in the warehouse district, and people were getting sick, and so they needed to separate those uses. So it really came out of a public health concern of what created zoning in the community. And so that's where the term Euclidean zoning comes from. So Euclidean zoning comes from that 1926 land use case of Euclid versus Ambler Realty. So Euclidean zoning is really separating land uses very specifically and intentionally. So when we start coming up with mixed land uses or form-based zones or something like that, that is no longer Euclidean zoning. So Euclidean zoning is saying commercial's property here, residential here, they're not going to meet. So that's kind of Euclidean zoning. And that was intentional when they developed it in New York because they were tired of people getting sick by putting all those uses together and that kind of thing. So any questions on this? That's kind of my jam. I love history of zoning. All right. I am a planning nerd. Okay. So really the purpose of, oh, next slide, please. Okay, so the purpose of zoning is making sure that those land uses are regulated and the physical improvements on that property are regulated. Once again, setting that expectation, making sure people know what is allowed on their property, and having those separation of land uses as we saw in Euclidean zoning, and regulation the density and intensity of land uses. So it's regulating the height of the building, the mass, the scale, and then regulations of improvements upon that land, such as roads, utilities. What are those going to look like? Are we going to underground utilities? Are we going to allow overhead power lines? Kind of what is that going to look like and what are the expectations? Next slide, please. And continuing with the purpose of zoning is the municipality may adopt reasonable regulations. So that's reasonable, which is the whole gray area of planning. But it's talking about that height of the structures, as I mentioned earlier, assigning restrictions on the use of street in order to reduce traffic volume, accidents, street maintenance costs, and allowable emergency services. Are the streets wide enough? Are they narrow enough? Can people get through? Is there pedestrian access? Things of that nature. And really regulating the size of lots in order to prevent destabilization of steep slopes. So making sure we're not creating that hazard, which goes back to one of those first slides we talked about. And establish setback ordinances to benefit the public and enhance the aesthetic value of the municipality, making sure that what your zoning regulations are getting you what you want and what you want in that comprehensive plan. So structuring them, and zoning regulations are also a living document. You could have a few land use applications come through and that's what it says, but that's not what we wanted. Then you go in and kind of tweak it a bit and figure out what is going to make it the way you want it to look or what use you want to attract to the community. And the courts have always upheld zoning regulations that permit a limited number of uses in certain zone districts or that specify minimum residential lot sizes. So the court is behind you when you start developing zoning ordinances, but obviously it's that reasonable word that we need to make sure of when you're creating those zoning ordinances. And that's the end of my slide. Yeah.
Would this be, did you say that was the end of your presentation?
No,
Oh,
end of my portion. So then Sheila's going to talk about you get to use your little,
okay.
but I want to answer any questions.
Would this be the time, or is there a time coming later where we might talk about Governor Polis's plan to overrule local zoning rules?
This is an awfully timely training, isn't it?
Yes.
Why don't we go through the next two parts and then we could spend some time
Okay,
on that
thank
as
you.
well. Okay, sounds great. Okay, next slide. So, one of the requests was to cover quasi-judicial review and ex parte communication. So that's what the next two parts are going to be about. Next slide. we kind of broke them into two parts. So first, we're going to cover quasi judicial review, and just wanted to give you a sense of what we're going to cover in this section. And we're going to talk a little bit about the difference between legislative and quasi judicial decision making. Then we're going to give a little bit of the legal context, especially cases from Colorado. And then we're going to talk about, we're going to give you some examples of process so that you can see the difference between legislative and quasi judicial process. And then we have some fun interactive questions or scenarios, and we'll get to use the props that we brought along. All right, next slide. So broadly speaking, planning commissions, most of the decisions that you're going to be in front of you are either can be categorized as legislative or quasi judicial. And legislative decisions, the way I like to describe it is you're making decisions about a policy that's going to have application across many different pieces of property. So more specifically, that's things like adopting plans, could be the comprehensive plan, a corridor plan, small area plan, neighborhood plan. Communities call them lots of different things. It could be adopting or providing recommendation to your town council on like an ordinance that would relate to planning and land use. But it's those broader discussions about how you'd like to see your community evolve or develop, but it applies to a lot of different parcels. And then the quasi judicial review, it's more of a decision about taking policies, your zoning ordinance, like Chris described, the comp plan, and applying it to a specific land development case. And so examples of that are things like variance cases or rezoning cases or subdivision cases. And quasi judicial, it actually means court-like. So when you're making those decisions, the idea is that you are serving as a decision-making body that's almost like a court environment, meaning that people have due process. They have the opportunity for a couple different things in order to pitch or share their case or their reasons why they want to put this land development case forward. And so in that, there's a lot of components to quasi judicial that are important that we'll cover at greater length. Next slide.
Can I just jump in and tell them,
Yeah.
on your agenda tonight, really everything that you have is a legislative function. So we're looking at the fence code, that is going to be legislative, considering the 3 mile plan, that's also legislative as well. So no quasi judicial decisions tonight. The last quasi judicial matter that you had was the rezone application. And so that was applying your zoning code, your rezone criteria to a specific property.
So when decisions are made by this body, does the person have the ability to appeal to another court or to the state or the county? Yeah.
Are you going to talk about that?
We're not talking about appeals. So go ahead.
Okay. And that is part of my presentation, but yes, absolutely. So a decision, and it's not the planning commission's decision, it's the board of trustees decision because they're the final decision maker. But absolutely, there is a process spelled out in the rules of procedure, state rules of procedure that allow a person to challenge a quasi judicial decision and bring it to the district court.
And I just wondered, is it an easy way to kind of differentiate the two by if there's an applicant bringing forward an item that they would like to have some kind of a vote on, they're asking for something, that's almost always going to be quasi judicial or not?
It more than likely, yes. I mean, even liquor license applications, those are quasi judicial. So typically, if it's applying the rules that have been set out and the criteria in those rules, then it is quasi-judicial. And there's also notice and hearing requirements. So you will have notice and hearing requirements in your rules, and that also supports a finding that it's quasi-judicial.
Thank you.
Great
This
questions.
question
Yeah.
probably classifies as like a heavy nerd kind of question, but thinking about the structure of the federal government of executive, judicial and legislative. So those are separate. So the purview of this is both judicial and legislative. So the same body of people can have input on the making of the rules and judicial. Do you know why that's set up that way?
That's a great question. I'm not sure I know why. I wonder if it's partially based on you all have been appointed to the Planning Commission because of your interest, your background, your passion for the topic. And so I wonder if part of it's more about this body having the capacity to review both. But I don't know if there's more history about why they.
I imagine that it's just, there isn't separation of power in municipalities because, well, I mean, you do have separation of powers because you have a municipal court judge who is deciding ordinance violations like model traffic code violations, those types of violations. The land use applications, the quasi-judicial, those aren't really judge decisions. So there isn't a separation of powers, but you do have other due process constitutional requirements that apply to your quasi-judicial decisions. So you do have to give notice. Property owner has notice, the residents around the property, the surrounding area get notice of the application and the hearing. Both sides have an opportunity to be heard. So always in your quasi-judicial hearings, you have the applicant presenting their view and their story and why they are entitled to what they're asking for. And then you have other people are given the opportunity to say, no, I don't agree, or this is going to cause impacts to my property. So you have those constitutional protections. The other constitutional protection, and this is something they're going to be talking about, is that all of the matters that you're considering are part of that public hearing. So it's all part of the record. And you're not having the ex parte communications, you're not prejudging matters, you're a judge that's unbiased and going to be fair.
Yeah, makes sense. Thanks.
Thank you, Jennifer. That was helpful clarification. Yeah, and just to build on that, so the concept behind quasi-judicial being court-like is that we're trying to build an environment for impartial decision-making. So people can evaluate a case in front of them using the same, all of you using the same information. And so as Jennifer described, this court case from Colorado really helped define further the three criteria for quasi-judicial. Just as Jennifer went over, one, you need to provide adequate notice. Adequate notice to, the concept is to people who may be impacted by the case. The second criteria is that you need to provide a public hearing. You need to provide people the opportunity to come share their thoughts, come share their information about the case. And then, or the land use application. And then the last criteria is that the decision-making should be using the information that's been presented through that process. And in addition, using the criteria or the guidance that's provided to you through your local laws. So those are the three things that really make it distinctly a quasi-judicial process. I'll keep going if there's not any other questions. Okay, next slide. Next, there we go. Yeah, thanks. There's more case law in Colorado that help further define the difference between legislative and quasi judicial types of decisions. And so we thought we'd just put it here. I'm not going to go into great detail. I'm sure Jennifer knows these cases backwards and forwards. So we could get into it more in detail. But the concept is that legislative action, it's usually reflective of some public policy. So we're trying to create that public policy that would apply more broadly across, in this case, land. And then quasi judicial action is really more determination of people's, I guess, rights in perspective of land and development rights, and determining whether the proposed action actually follows the policies or local laws that are in place. So that's the key distinction. Next slide. And we thought it would be helpful to maybe talk through some hypothetical processes or kind of map out what the process might look like. For a legislative process, this is an example, actually what we were talking about earlier, of developing a comp plan. And so typically early steps are trying to understand what resources a community has for developing a comp plan. And so this might be, while it's part of the Planning Commission's responsibility to ensure that the process makes sense in order to develop a comp plan, you're probably working with the Board of Trustees to understand the budget for this type of process. And also then understanding what kind of assistance you may need. Many times communities hire some sort of planning group or planning firm to help them through the process. So those are the early stages. And then it says town staff compile the comp plan. And usually it's with the assistance of consultants if there's a budget to do that. And this is a really broad description of compile the comp plan. It's usually a very long process. As some people have said, they've been through it before. So it usually involves doing some sort of plan for public engagement, public meetings or community meetings. I've seen some communities do a lot of different outreach methods. They may do surveys to community. They may do stakeholder group meetings, meaning they may meet with school districts and park and rec districts and any other stakeholders in the community to understand what the needs are, what their ideas are. And then through that public engagement process, eventually you get to a draft plan. And that's where the Planning Commission's review and approval process comes in. So, and again, I've seen it happen a lot of ways. I've seen communities come up with an early draft and then they bring it to Planning Commission to get initial feedback. But eventually a plan comes before the Planning Commission, and then the Planning Commission's job is to approve the plan if it seems like the right direction to go for the community. So that's an example of a legislative process. Next slide. And then we thought we'd talk through a little bit about what a quasi-judicial process looks like. And I can't read that. It's too small. Sorry, my notes are too small. Thank you. And the variance request. So a variance request is an example of a quasi-judicial process. So you receive a property owner will submit a land development application to the town for a variance, and then town staff review it. Usually there's a step to make sure the application is complete, and then the application is then an active application. Like I explained before, the quasi-judicial process, you always have notice of a hearing. So you let people know that this application has been received and that you're going to have a hearing to discuss it. At the hearing, you allow both the public and the applicant to have time to present their feelings about their information and facts about the land development application. And often, and I went on your website and looked at some of your previous planning commission packets, and it looks like you also have times when you have staff present different pieces of a land development application. So all that happens in a hearing. And one of the things that you're developing, because it is court-like, you're developing your record for that review, so that you're making sure any communication that that has been provided, that all of you have access to that communication, that it's been documented in a record. And then usually the decision about those cases, you develop findings of fact. So you're again, as I explained with that, with the different criteria, you're applying either the zoning ordinance, comp plan information, and putting that into findings of fact to determine should this application be approved or denied. So that's the general process for a quasi judicial review. Okay, next slide. All right, we thought it'd be kind of fun to give examples, but maybe I'll pause for questions. Any questions before we go on to examples?
Just one for Attorney Mattson. 2013 is our last comp plan, is that right?
Yes.
Okay.
Perfect. Okay, we'll go on to examples. This is the fun part. So I'll read through them, but they're also on the slide. And then we are going to use our props. We have one prop that says legislative and one prop that says quasi judicial. And you are going to let us know by raising those what you think this is. So the Town of Nederland staff present a proposal for an amendment to the town code of ordinances to allow campgrounds and resort cabins on all mountain residential districts by right. So is this an example of legislative decision-making or quasi-judicial review? Yay! All right. Anybody want to share why?
I will.
Sure.
Anybody else want to go?
Yeah, I was just gonna say because it's a outright change to the code. Currently not allowed, and we'd be discussing changing that to allow that.
Very good.
It affects the entire town, anybody that would future want to do this.
Hey, Billy, you're unmuted, by the way.
Whoever's online, please mute yourself.
Yes, so exactly. So it's a decision that is that is changing a regulation or a code in order to apply to many areas or the whole town. All right, we'll go to the next one. Scenario B. So the Town of Nederland recently approved an amendment to the Code of Ordinances, which will allow campgrounds and resort cabins as a conditional use in the Mountain Residential Zone District. A property owner in the Mountain Residential Zone District submits a site plan for a proposed resort camping experience on a portion of their property. Is the review of the site plan legislative or quasi-judicial?
And I'll fall back on it being quasi judicial because there's an applicant coming and asking for a specific type of use as opposed to something that will be broad reaching zoning or something across a large area or the entire town.
Great explanation. Yes. All right, we'll go to the next one.
And a little commentary that Nederland doesn't even have a site plan process. So even extra points for all of you.
Yes, because we threw a curveball in there.
I think we need one more.
Right. There's no site plan process. So there can be a process in your zoning code for a site plan review. And that isn't something that exists in the Nederland code, zoning code.
And is that just because it's unnecessary or?
It's just because it's something that, previous planning commissions, previous board of trustees have never decided to adopt. A site plan process is a is an extra step in planning and development. And site planning is usually a more detailed process. So, what is like applying design standards to a development? And maybe Chris and Sheila could talk a little bit about what a site plan process is.
Sure, I can explain. So site plan usually comes after the use has been determined that it's approved use, or it can come after somebody has proposed a rezoning and the rezoning has been approved. But the site plan stage is essentially the applicant would produce a document to demonstrate that they are meeting all the dimensional requirements of whatever the zone district is.
And would that come before the application is turned in, or is this after the initial application?
Yeah, so a lot of communities don't require that at the time that you're proposing a rezoning. Usually it's like the next step. Many communities actually make those decisions administratively. So as long as the use has been approved, or if it's a use by right, then staff usually review those site plans and ensure that they meet the code.
And where Nederland would review it to make sure that the property owner is meeting the code related to setbacks, height, those types of things, that would be in the building process, getting a building permit.
So I get that. So my question is, what's the difference between what, the process we have in place versus a site plan process? Like the example in my head is, say somebody comes and they want to do a detached or attached ADU, that's a recent amendment to our code. Part of that approval process would be them showing on an ILC or whatever it is that they're meeting the setbacks and the size requirements and all this and that. So how is that different from a site plan process versus just the process of approval for that thing that we have in our code? Does that make sense?
You want to?
Specifically in Nederland?
Like-
I'll let-
Well, so
Like what
in
are we
Nederland,
missing
we
that
don't,
a
there
site
isn't,
plan process would provide?
a site plan process would provide maybe greater oversight over the development. There isn't anything in town code that requires, say, on a commercial development, that there's a specific number of, that there's landscaping required, or what the materials or the appearance of the structure looks like. Those are additional features that could be added to the code and part of a site plan process.
Got it. That makes sense.
And just piggyback on that, the PUD that we're going to start requiring, that's more about the overall project plan and not about the actual zone and regulations. Is that correct?
Yeah, the PUD, what you're looking at there is you're looking at uses. And then you're also looking at determining what all of the setback requirements are, the heights, all of those pieces to the zoning. So PUD is really specific zoning for that lot
Okay.
or several lots.
And a site plan is
It's
ticking
drilling
the
down.
boxes that you're proving that this is going to be built out this way.
Right.
Okay. Okay.
So I've seen it come into play where a community has architectural guidelines that are very specific. So that's kind of where site plan comes in. You're reviewing the landscaping, you're reviewing the type of sod, you're reviewing the type of, shrubs, trees, what size they are. Is the roof a lazy 7 roof? Is it hip gable? Like you get down into like the nitty gritty of what it's going to look like, not necessarily the structural components like you would in a building permit. And does it meet residential building code, commercial building code, things like that? But it's looking at the aesthetics is where a site plan process comes in.
So if we did have a more specific site plan process, then theoretically we would have less to subjectively discuss on any given PUD or application.
Well, without the site planning process and without those specific items being part of your regulations, the town zoning code, you just don't have oversight in
Right.
those matters. So you can't say, we don't like this pitch of a roof. We don't like, the style of the building.
Right.
That just can't be part of the discussion. I mean, it sometimes is, but it's not a denial. You can't deny based on that.
Right.
But what Tim said, though, it actually adds another layer to the review.
Right.
It's not, so there'll be one more layer.
Right.
I think what the town has done in the past, so we actually haven't even used the subdivision ordinance all that much. It's been basically PUDs as we annex property. And you're exactly right. We certainly took it to a level of, where's the roads, streets, built, and we even have building envelopes, setbacks, things like that, but certainly not the landscaping. What does a building look like? I think we probably took the PUD process as far as you could go. And mixed it with the subdivision, which it certainly states in our thing that, use the subdivision ordinance, which really wasn't all that complicated. And although we just reviewed it a year ago. So that's what we've always done, was use the PUD, but we certainly didn't do those, the next step. And we counted on, when the houses were being built for staff and the building permit process,
Right.
just to make it to be what it would be, but not, certainly did do architecture, landscaping, any of those things.
All right, we're halfway through our slides, so
Okay, we'll keep going. All right. Next slide. All right, this is our last scenario on quasi judicial review. So a property owner who lives in the Mountain Residential District wants to provide luxury outdoor camping on a secluded portion of their property. Campgrounds and resort cabins are explicitly called out as prohibited uses in this zoning district. The property owner files a variance request with the town of Nederland for permission to override this use restriction to realize a higher economic use of their property by providing private camping opportunities. The property owner further argues that the public lands in the area are overrun with dispersed camping, and this would help ease pressure on public lands. So, does the review of this request by the Planning Commission fall under legislative or quasi-judicial? That is right. Quasi-judicial, yes. Very good. Great job. We could. Does anybody want to make one up on the fly? Is there one in your head that you just would love to try to do? What kind of decision is that? Yeah, exactly.
So I have one, under the Nederland Code in amendments, there's a provision that allows for, let me get to it, that allows a person to come to the Planning Commission to submit an application for an amendment of the chapter. So an individual can submit an application and say, I think that you should allow for a greater height in the central business district to 40 feet. Okay, great. Yeah.
Great work. I'm so impressed. All right, next slide. we were going to next walk through ex parte communications. And so, and actually you can, yeah, perfect. Thank you. So what we thought we'd try to answer tonight is, what is ex parte communication? Why is ex parte communication important? And what do you do if ex parte communication occurs? And then of course we have some scenarios, because scenarios are really fun. So next slide. So the meaning around ex parte means one-sided. So the concept is that it's communication between one member, it could be more than one member of a body that others are not privy to. So it occurs when a board member in a quasi-judicial proceeding communicates directly or indirectly with any person or party in connection with a matter before the board, absent of notice and opportunity for all parties to participate. Next slide. So to talk a little bit about why that matters. So we just talked about quasi-judicial review and how important it is to set the stage for impartial decision-making by allowing due process, by having very specific steps that you make sure that you have notice to anybody who may want to weigh in on the subject. You allow a public hearing where people can be heard and have the opportunity to speak and share their perspective, and that you apply findings of fact. So when ex parte communication happens, the due process breaks down, because it means somebody on a planning commission has had a conversation about a particular land use application, and not everybody had that information. And so it starts breaking down. There wasn't notice, so you couldn't all be there when the communication happened. And somebody had the opportunity to share information, but it wasn't in this public setting. So the challenging piece is that when you're deciding on cases, if you're not following this process, you leave opportunity for people to bring a legal argument against the decision that you've made. So that's why it's particularly important that you think through ex parte communication. With that said, it's really tricky, right? Because people that are coming before you are a part of the community. They're your friends, they're your neighbors, they're the business owners in the community. And so sometimes it's hard to navigate, like, wait, when is this becoming ex parte communication? And when is this just a friendly conversation with my neighbor? And so we're going to try to walk through a little bit of what to do and then some scenarios. So maybe we can think through strategies as well for what to do. Next slide. Oh, sorry, I got behind on my slides. So I've already talked about this. Next slide. Okay, so what do we do? First thing is, when you're in a conversation and you realize, I think this is ex parte communication.
Can I just
Yeah.
jump in really
Sure.
quick? So the time that this ex parte rule applies is when the application is filed. So when your application, the land use application has been filed, that's when we need to be focusing on no more ex parte communications. And Britt and Miranda and myself are really going to work on sending you and the Board of Trustees a reminder saying this application has been filed, it's coming before the Planning Commission, the ex parte rule applies.
Great. Thank you for that clarification. So what happens when it occurs? So there's an active application, you have a conversation with someone, and you realize, oh, wow, we've just gotten into a conversation about this application that's active and going to be in front of me as a planning commissioner. First thing to do is end the conversation. And I'm a big fan of thinking ahead of those one-liners that you can say to kind of back away from a conversation. But it could be as simple as just saying, I'm glad you want to share this with me. I'm a part of the Planning Commission, and per my role on the Planning Commission, I need to pause because I'm supposed to hear this information. at the same time that all my fellow planning commissioners have a chance to share this information. And then the other thing is to disclose or to share that this happened. It's important to share it on the record. I mean, at some point on the record to make sure that you've shared that you've had ex parte communication. But I would say at the end, we say always discuss this with your legal counsel and have that happen early. So reach out to your legal counsel, and because sometimes it's hard to decipher how, well, I had a conversation, I didn't really hear information. When does it become ex parte? And all of that, your legal counsel can help you through and coach you through. The reason it's important to get it into the record is because, and I know Chris has really good examples of that in places she's worked, where if that doesn't happen, let's say the ex parte communication wasn't necessarily consequential, like it didn't change the way you made your decision, but people could challenge the decision and find evidence that that conversation happened. And if it's not in the record, that could be good enough evidence to change the course or to turn that decision, if you will. So it's important to follow those processes. And I don't know if Jennifer has, as your legal counsel, even more guidance on what to do.
Well, the goal is with making that disclosure that you did have this conversation or you learned particular information. I mean, ex parte could also be conducting your own research. And so, researching a particular issue, even going to the site and taking a look at the site can be considered, because what you're doing is you're outside of the hearing process, you're gathering information. And that's really what an ex parte is you're hearing information. And the goal is that all the information that you're basing your decision on is part of the hearing process. And that's a fairness thing. It's, you want to be fair to the applicant and you want to be fair to anybody, neighboring property owners, anybody who might be opposed to the applicant. So that's why you make the disclosure, is so that you say, well, I had this conversation with XYZ person, and they shared with me that there were going to be noise mitigation was going to be applied to this particular special review use. And so, and I'm making this example up and it's not coming out very well, but just so that both sides are aware of what you've heard, if that makes sense. And they can speak to that as well. And you could also be then challenged for being biased.
So just on the disclosure part, just for my own, because I might have had this wrong all along. Someone at church or someone in the grocery store comes up and says, hey, this new project's coming on, what do you think? And you immediately say, yeah, I can't talk about that because I'm on the planning commission. You don't have anything else. You still need to come and disclose that? No, you don't. As long as you end communication
Yes,
immediately. Okay,
right.
that's what I wanted to
Yeah.
do. Thank you. As long as there's no discussion of items. But for example, the example that I think you're reaching for was a grow house was built in Nederland. Maybe I was out on a hike and I ran into the owner and he's out there and he tells me about all the filtration he's going to put in there. And now I have some additional information that the rest of the planning commission doesn't have.
Right.
Okay. Thank you.
Exactly. And I think what you did just there in consulting your legal counsel is exactly, it's a great step, right? I ran into someone at church. They didn't share any facts or information, just that there is an application. Is that ex parte communication? That's exactly what you should do.
So what if that communication like that is like hearsay? Like, say I live in Big Springs and there's a guy in Big Springs who has a new application for his glamping thing, and that application's been submitted. It's, and we're going to be discussing it. And then I'm at the Mexican restaurant at the bar, and my other Big Springs neighbor sits down next to me and like, oh man, this guy Jeff and his glamping thing. Oh, what a pain in the ass this is going to be. Did you know he's doing X, Y, and Z and blah, blah, blah. And gives me all this hearsay that may or may not be true. I don't know. But I might sit there and listen to him because I'm drinking a beer. Like, is that information that I need to like shut down right there, or I need to share this hearsay with the rest of the planning commission?
Yes. So yes, I would, yes, shut it down. Because that's somebody who could come to the hearing and could submit public comment at the hearing and say all these reasons why he doesn't like the glamping application. And that way, everybody gets to hear this, and the applicant gets to hear it and can speak then to what is hearsay and say, no, that's not right. This isn't the way it is. So that's why, yes, it doesn't matter who it's coming from.
Yeah. So sort of similar but opposite, say the same situation. But I have a personal and valid opinion on the matter and how it applies to our code. And maybe I want to share my opinion with my neighbors because it affects them too. But I'm not taking information from them that I'm hiding from other planning commissioners. I'm just sort of sharing my opinion,
So is it a legislative or is it quasi judicial?
quasi judicial.
Then you shouldn't be talking about it at all.
What if it's legislative?
If it's legislative, yeah, definitely.
Okay.
You can talk about it. You can say, hey, the planning commission is going to be talking about fence code tonight. I want to hear what your thoughts are. Give me feedback.
Yeah.
Definitely.
Gotcha.
You can talk about it.
Well, that answers my question for
Yeah.
So it sounds like when it's quasi judicial, blinders and earmuffs, everything they
Yeah.
who
And
get educated or hear about should happen here.
right.
And if somebody from the public wants to talk about it, tell them to come.
Absolutely.
and that's
Yeah.
it.
Come to the meeting, submit public comment if they want. They can send emails to town staff, and all of that will be submitted in your packet. So you'll all get it at the same time. I mean, think about it the way that that Sheila was describing the quasi judicial, is that it's judge-like. So if you have a judge that is deciding a murder trial, does that judge gather evidence before the trial and listen to people and, do research and find out information before the trial? Absolutely not. I mean, the only thing that the judge is considering is what is heard and said at the trial. It's introduced as evidence.
So to take your scenario just a step further, like say that I know that there's something coming up on the agenda. It's already in the packet. I know that my neighbors would be interested in it. Is it acceptable to tell my neighbors, hey, you should check out this packet?
I think that that's fine. I mean, if it's, and you're talking about a quasi judicial.
Yes,
Yeah.
Okay.
I don't,
Yeah. That could be.
it is.
Yeah.
Just spreading the word.
It is. Yeah. I mean,
Yeah.
you're not gathering information. I mean, you might even say beforehand, I can't talk to you about this, but you might,
But pay attention to this.
yeah.
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 Okay, thanks.
I will say I had a big misunderstanding. I came to a public BOT meeting to, give public comment. And at that BOT meeting, a couple of the trustees said, hey, we listened to your planning commission video. We watched it earlier today on this very issue. And I immediately thought, well, gosh, that's ex parte communication. When we received evidence and you've already reviewed it outside of your BOT hearing. And actually it was Attorney Mattson who was able to respond to me and say, well, but that's part of the packet. So it's part of what they're able to review. And it just was a misunderstanding on my part on how that worked. But I totally thought 100% they were wrong and just didn't understand how that worked.
I think we all did, but I would say that's an example it's like almost as close as you come with that ex parte issue. I mean, it was really, and, because I think we had always thought before that, that wouldn't be appropriate. So it's unbelievable process of learning step by step to see this. But that was a real learning one. I know Steve had, same thing with Steve Williams. He had to really think about it too, to understand it.
Yeah, all of the information that the town staff puts together in terms of the agenda memorandum, those are all going to be part of the record of your hearing on the planning, on the quasi judicial matter. So if you have a link to a YouTube video, that's part of the record.
I saw it an hour before the rest of the board.
Well, and I'm curious then, that's a good point. That was just what I was going to bring up. So what happens if then not all of the BOT members are able to listen to that link and watch it? Because not all of them had. I think 2 of them had said, we had a chance earlier today because it had come out that day to listen in and kind of get a preview. I'm just curious, has that changed the scenario at all?
Well, it's on planning commission members and it's on the board of trustees to be prepared and to have reviewed the material in advance. It's also on the applicant to present their case and to present the reasons why their particular application meets the criteria. So if there's important information that should be presented, it should be presented at both the planning commission and at the BOT meeting.
You all are coming up with fantastic scenarios. So I don't know if we want to go through all these. We have 3 scenarios for ex parte communication. We could just do 1 or 2 because I know we're coming upon 8 o'clock. So I want to make sure you all get a break before what's that?
I do, but it covers a lot of what we've touched on. I know we can get through it pretty quickly.
Great. Well, why don't we go ahead with the first one? Although I think we've had one very similar, but here we go. You're enjoying a beautiful Colorado summer day, attending a picnic at a neighbor's backyard. You meet a new acquaintance and strike up a conversation about what you love about living in Nederland. The new acquaintance shares about his various ventures in establishing local businesses, and now he has dreams of opening up an auto body shop. At some point in the conversation, you realize that his plans are in motion and he is working with consultants to explore his options for rezoning the property. What do you do now that you realize that you've heard much of the background? And this, well, I'll just leave it at that. of what will soon be a development application in the town of Nederland.
Yeah, I think if it ends up going in, then you should notify council and disclose it, and should end the conversation right away when you realize that it's going to be a rezone.
And I would also agree that you probably want to disclose it, but because it's not become an application yet, are you then kind of on a little bit of safe ground there until then? And so then you shouldn't have to recuse yourself from actually being part of that, or am I incorrect on that?
Go ahead.
Okay. So that's 2 different things. One is the ex parte communication and one is recusal. And so ex parte rule applies once an application has been filed. Communication before an application has been filed is okay and is not ex parte. I mean, if you think about it, until you have an application, you just have dreams and goals and desires. You don't have anything that is hard and fast that's pending. It wouldn't be a bad idea that if this neighbor's rezone comes to the planning commission, just to say on the record, I did have this conversation before the application was filed, and I did talk with the neighbor about the rezone. And maybe put in some details about what was said. Recusal only will come in if you've prejudged the application. So if you have, or if you have a conflict of interest. But if you cannot be fair and unbiased as a judge, then you have to recuse.
Okay, so I think I'm understanding there that one is just disclosing you had the conversation, and the other is I don't feel like I have a conflict or something. It turns out that guy's my brother-in-law, and maybe I shouldn't be the person to hear it, whatever the case may be. So two separate issues.
Right. Unless you've had, you know, you went on a week-long vacation with the developer and there's no possible way that you could disclose all of the ex parte communications that you had.
The appearance of impropriety, yes.
Great. Should we try one more? Does that work? Okay, let's go slides ahead. This one's a fun one only because I think it's a little bit more real world today. So a developer who has an active land development application with the town of Nederland posts something on social media and tags you in the post. The post includes her explanation of how her proposal is beneficial to the community. How do you handle the situation?
Yeah, you know, you don't.
I don't know.
Deleted
Yeah, did you read it? If you didn't read it, then I don't know.
You delete Facebook. It's a waste of time.
My guess would be that you would need to disclose it because just by virtue of now there's a record that they have sent you this communication, whether you actually read it or not.
Could you include it in the packet?
No.
That way it's in record for everyone? Then it wouldn't be ex parte?
Yeah.
Yeah?
No, I think it's no different from, there's an article about a project in the newspaper and everybody in town gets the newspaper.
Or what if somebody sends you an email?
Sure.
I mean, that's really the same thing as someone sends you an email and you include it in the packet.
So you forward it to town staff and get it included?
Yeah, so I think the big catch is like in a news article, theoretically anybody has access to that if it's a public publication. Sometimes social media, depending on who you're friends with or what the situation is, everybody may not have access to that too. So you just have to keep that in mind. But if you print it out, include it in the packet, then there you go. Awesome.
You really haven't crossed the bridge unless you would respond to that person about that email or that Facebook article, then went back and made a comment on it. Now you're part of everything we just talked about.
Want to answer that?
Well, if you responded and said, I love this project, I'm going to approve it no matter what everybody says, then we have some problems and we have to talk about it and likely you need to recuse yourself.
It sounds like the theme is though, when in doubt, go ahead and disclose the communication just on the safe side.
I was going to say one time I had a professor who told me disclose, 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 disclose. And the answer is always disclose. So, yeah.
Great. Well, that's all the scenarios we did. If you go to the next or two slides ahead, we did include some resources if you want to look deeper into these topics. These are all active links, so you should be able to get to the websites. The first one are resources from the Department of Local Affairs. They, as I think I mentioned at the beginning, they do a Planning 101 workshop. They've done it for years. It's usually almost a full day. I think Jim said he's taken it. Right now, they're in a pause mode. They hope to start that back up in the fall. So highly recommended. It's a wonderful course. And then the second slide of resources is from the American Planning Association. And so there's a number of different resources there. A lot of it you all already have down. I mean, there's things about staff reports and what to include and that kind of thing, but it's just a good resource if needed. And that's all we have. And I just wanted to say thank you. Thank you for letting us come. We're thrilled to come visit our member governments and to get to interact with all of you. And if you have any other questions or if there's topics you'd like us to bring more information on, we're happy to do that in the future. Thanks.
That's excellent. Thank you so much. I appreciate that, Sheila. And if there is, when you guys do get dates of those upcoming planner 101 type sessions. That was great. What I found very helpful about it, it was an all day thing that Steve, our chairman, and my wife, who is also in this field, went to, and was that you're there with sometimes town staff, mayors. It's a wide spectrum. And then there was breakdowns into small group activities, and it got much more in depth. And they came up with some extremely interesting scenarios where it wasn't as easy as this for us to figure it out. So, but thank you so much for your time tonight. You
Yeah,
too,
thank you.
Chris.
It was great.
Can we discuss a
Oh,
quick discussion of the,
well, let me ask Attorney Mattson, can we push your training to another time or not?
No, that's fine.
oh,
Yeah,
I'm sorry,
definitely.
there was more to do?
There was one more section, but I'm like with you. I would kind of like to hear your feedback on what you think about, Governor Polis's plan on overriding local zoning.
Sure. I'm not sure I personally have an opinion, but I will share what we did at DRCOG. We did review the bill. As you know, it's been through many iterations. We reviewed the bill as introduced with our board on April 5th, and our board did take a position of oppose. As introduced, I'm sure you all have been reading about it, perhaps even have dived in deep with the bill. It did go into great detail on changing different portions of land regulations for all communities across the state. And again, different sections applied to different, they did have these categorization of different kinds of communities or different municipalities. But it did cover ADUs, middle housing, which was housing from 2 to 6 units, transit-oriented areas, and key corridors. And so as introduced, it was proposing regulations in that regard. There was also a section 2 that talked about additional elements for comp plans that was quite interesting as well. As I understand it, though, I don't think it went to the Senate floor today. I heard it may go tomorrow, but it did go through at the Housing and Local Government and Housing Committee on the Senate side. They reviewed it. They made 19 amendments or 18 amendments. And then before it went to appropriations, because it does have 15 million attached to it, it needed to go through appropriations, and the appropriations committee reviewed it this morning, and they actually reviewed, they had a strike down version where they actually cut out quite a bit of the bill and kind of rewrote many parts of it. So my read on it yesterday, when I read it, it keeps the structure for requiring housing assessments, housing needs assessments for communities, and housing needs plans. However, it did add opportunities for communities to work on that regionally, meaning they could work on it with other communities. They wouldn't necessarily have to produce their own plan. And then it kept some guidance. They're going to create a body called the Multi-Agency Committee that will include representatives from different state departments within the state, representation from metropolitan planning organizations, so organizations like DRCOG, representation from, I think there's representation for different kinds of communities, and then also representation from a housing expert. And the idea of that group, now that they took out most of the preemptions in the regulations around ADUs, middle housing, transit-oriented areas, and key corridors, they took that out. What they've said in this current version is that that multi-agency group will provide guidance by the end of 2023 to the General Assembly about what to do next in order to encourage housing supply across the state. So it took most of that out. With that said, for this body, the piece that I would direct you to is that there's a section in there that talks about different elements of the bill that apply to comprehensive plans. And so there is a lot more guidance for comprehensive plans, and even a requirement that communities update their comprehensive plan every 10 years. So that's probably an area that would be of great interest for this group, and of course for any town, I think would want to.
And that's SB 23?
213.
213. 213. 213. Okay. And then is there not a House version? It's just that
It
right now?
hasn't gone to the House yet. So
Okay.
I heard it was going to go to the Senate floor tomorrow is
Okay.
what I heard, but I did not double check that on the website. So please do your research because I may not be right. So,
And just so, and in case everybody isn't aware, as I read through that, the thing that jumped out at me was basically it was superseding local control for how much lot coverage you could have, setbacks, to zero from what the initial proposal was. And I thought, gosh, that pretty well just Bigfoot's our entire planning commission. What's the point of having one if this goes through? But you're saying most of that all got changed.
the version that was approved or that was reviewed by the Appropriations Committee this morning, yes, that was
Okay.
taken out. But what I understand is it still hasn't gone to the House. So for sure, keep tracking it because I guess things could be added back. You don't know. So
Sure, sure. And
Mhm.
at some point, I'm guessing that we're going to ask for staff and Jennifer to give us a readout on what ends up passing. But you think that's still a ways off? We're looking at next year before anything will be implemented?
I guess it's hard to say, but at least what's required per the way the bill's written at this point is a report or recommendation would go to the General Assembly next year, next spring, or by the end of 2023, I think was the date, if I have that correctly.
So just so you all know, the Colorado Municipal League has really come out pretty strongly against Senate Bill 213 and worked to get a lot of communities to support the opposition to 213. The Board of Trustees did pass a resolution opposing Senate Bill 213. And right now, as the way the bill is drafted with all of those amendments, the Colorado Municipal League has indicated that it will publicly support the current version of the bill, provided that there are no, provided that it's in that form and there's no amendments to put back sections in the bill. And the really significant thing is what you talked about, what you touched on, Commissioner Reese, is that planning, local land use regulations have always been a matter of local control. And this bill made a sweeping statement that in this area of housing, that it was a matter of statewide concern. And so that municipalities really wouldn't have a say as to what their zoning regulations would be related to density, housing density.
Okay, thank you so much for all of your great information. I know we went a little longer. I knew this group would be interactive, so I appreciate Attorney Mattson. If you wouldn't mind waiting until we can fit that in on a different night when we have a little less on our agenda. Let's go ahead and take a 8-minute break, and I'd ask all the commissioners to be back at 1 minute till 8, and we will start promptly at 8 o'clock. coming to them. Check, check. No, I can't hear myself coming out. There we go. All right, if we can call the Planning Commission meeting to order for April 26th.
Meeting call to order at 8 o'clock.
Will you call the roll?
Absolutely. Vice Chair Reese,
Present.
Commissioner Cornell,
Present.
Commissioner Dye,
Present.
Commissioner Rivera,
Present.
Commissioner Duggan, and Pro, I don't think he's here. Pro Mayor Tim Spaulding's not. So we're gonna have Commissioner Herring, Chair Williams, and Commissioner Glasser are going to be absent.
Okay, thanks very much. Did everybody have a chance to review the minutes? Okay, if there's not any issues, I would accept a motion to approve.
So moved. For I'll just say so moved for the last meeting minutes.
Second? Do we have a second?
I'll second.
Okay, will you call the vote?
Commissioner Dye,
Abstain, I was not present.
that's fair. Commissioner Cornell,
Yes.
Commissioner Duggan,
Yes.
Commissioner Rivera,
Yes.
Vice Chair Reese.
Yes. Okay, at this time, if we have, I'm going to make a quick statement and then I'm going to open it up to public comment on a non-agenda items. We are going to have a presentation tonight from Mr. Mitchell that is informational only. It is not been turned in as an application, so there will not be public comment accepted on this until that formally comes before us as an application form. At this time, if you would like to speak for 3 minutes on a non-agenda item, please come to the microphone or let yourself be known online. All right, last chance online. Speak up now. Okay, hearing none, we'd like to move on to our meeting items. And does Mr. Mitchell need to be here? Oh, there he is. Sorry, I didn't see you over there. Sorry, that chair's a little high. Okay, so we are going to have our first agenda item of the evening is going to be a presentation, informational presentation on Ron Mitchell's Amsterdam project. So if you would like to introduce that, Britt, who's going to be giving the presentation?
Yeah, so the presentation is going to be done, Debbie Davenport. We're also going to have Kate, who's going to be presenting the plans online, and Ron Mitchell.
All right, thank you. Please continue. Yeah. Just make sure that is on there. Yeah, there you go. Okay. And one more informational item. Please, commissioners, get close to your microphone when you are talking. Mr. Mitchell has a little bit of a hearing problem, and it will help all of us.
Yeah, would you stay within an inch of the mic?
Bet.
Okay.
Hi, my name is Debbie Davenport, and my daughter Kate Barnett is online presenting the drawings and model. Together, we own and operate Caribou Ridge Architecture.
Brett.
Okay, just checking. Kate, can you hear okay?
I can hear.
Great, okay.
Thanks.
Today, we're sharing our proposal for a mixed-use building that will be located to the east of the bus station and west of the Kathmandu Plaza and Restaurant. It's well known that Nederland has a housing, parking, and commercial space shortage. While there's been some progress in recent housing developments, there's always a need for more places for people to live. Another factor that we were taking into consideration with this lot in particular is the adjacency to the RTD Park and Ride and the volume of Ned residents and Eldora employees that rely on the bus for day-to-day transportation. This proposed mixed-use building, or as we're calling it, the Amsterdam, is being developed in response to the community housing and parking shortage and connecting a vital transportation system to the downtown area. We also want to mention that many of the goals of the 2013 comprehensive plan are being met with this design proposal. We'll talk a little bit about the building concept. Netherlands' rich history and mountain setting is why many of us have been drawn to calling this town home. The miners that settled in Netherlands, the proximity to popular transportation routes, and the resulting tourism all influenced the architectural makeup of the town. Several of the historical buildings that have been preserved today in the central business district show the simple design and detailing, traditional storefronts, and wood construction of the era. Netherlands' Central Business District design standards were developed in response to this historical context. From these standards, the Amsterdam design includes rectangular forms, various roof designs including parapet roof fronts, recessed storefronts, zero lot setback, large display windows at the street level and vertically oriented windows at the upper level, wood siding, and boardwalks along the front facades. Stone buildings with shallow archways such as the Mining Museum also feature notable characteristics of the town's early mining history. Now we're going to talk a little bit about the programming and the context of the building. The lot's bordered by Highway 72, Jackson Street, and West 1st Street. The Amsterdam will include a subterranean parking garage for building tenants, a main level restaurant and shops, leasing office and building manager's apartment, accessible stair and elevator towers for tenant use, and 22 apartments, which are distributed between the street, second, and third floors. There will also be 9 tenant parking spaces across the street adjacent to the library parking, and 20 public parking spaces for shop and restaurant customers who will also have access to EV charging stations. An 8-foot wide covered public sidewalk will connect the customer parking with the street level restaurants and shops in the sidewalk along Highway 72. On the east side of the lot, in the 15-foot setback, tenant dumpsters, building utilities, and a restaurant delivery garage will be located. This setback allows for the building services to be located out of the way of the main thoroughfare. Tenant waste will be sorted by an employee to ensure proper separation of trash, compost, and recycling. A whole building generator will be located adjacent to the boiler room in the event of a power outage. And the apartment manager will have a parking space near the leasing office. On the roof, there'll be solar panels to supply energy for the building, as well as a water holding tank to ensure that there's no disruption in water flow throughout the commercial spaces and apartments. Roof drains will also direct rainwater and snow melt to an underground retention pond so that the water can be properly directed to the storm drainage and not add to any road level drainage issues. In context to the surrounding buildings, the Amsterdam will be within the 35-foot height limit, which will complement the Kathmandu Plaza and restaurant. Now that we've covered the overall building program and context, we'd like to take you through each level, starting at the subterranean parking garage. The lower level of the building will provide 12 standard and 2 handicap accessible parking spaces. Tenants will be able to access the parking garage via a ramp entrance from Highway 72. This entrance will only be accessible to tenants who have a garage door opener. Tenants will be able to exit the garage via a ramp exit to 1st Street. On both the north and south ends of the building, there will be a tenant bike and ski lockers. An accessible stair and elevator tower will also be located on the north and south ends of the building. Only tenants will be able to access the stairs and elevator at the basement and main levels with a key to ensure their safety. Also, at the north and south ends of the building, there will be water retention ponds that will dispense the stormwater below street level to the south. The eastmost portion of the basement will house mechanical and building maintenance equipment. At the street level, there'll be a restaurant, 2 shops, customer parking, a covered public sidewalk, tenant access to the accessible stair and elevator towers, 2 studio apartments, an apartment leasing office, a building manager's apartment, and various building utility rooms, including the fire sprinkler system room. The primary purpose of the restaurant is to provide commuters a place to grab something to eat and drink on their daily commutes and provide space for people to wait for the bus or work for the day. There will be both sit-down and take-out options for food. The space can also be used in the evenings as a communal hangout space for the tenants. The covered sidewalk will also have seating for people to eat outside and will be outfitted with garage-style doors to protect the sidewalk during the winter months. We're intending to provide planters at each column for vegetation as well as EV charging stations. We'll cover the apartment amenities as we discuss the 2nd and 3rd floors. The 2nd and 3rd floors have identical layouts. Each floor has access to the accessible stair and elevators at the north and south ends of the building. Each floor has 1 studio apartment, 4 one-bedroom apartments, 3 two-bedroom apartments, and 2 three-bedroom apartments. The stair towers will also include janitorial supplies, the internal downspouts, and at the 3rd floor, a roof access ladder. Each apartment will have routine trash pickup to ensure that any tenant trash is sorted properly. Each apartment will have ample daylight and access to fresh air. The apartments will feature utility closet with hot water heaters and washing machine and dryer. The bathrooms will meet accessibility requirements and include a tub shower, toilet, and vanity sink. All the kitchens will include a refrigerator, dishwasher, sink, oven, and ample storage space. So thank you so much for letting us present the building, and I'd like to see if you have any questions.
All right, if no one else will start, I'll start.
She was signaling, I was waiting for her to finish. She was doing sign language. Debbie, you mentioned the adjacent parking.
Mhm.
Where specifically is adjacent parking?
So it's right next to the, you know where the sidewalk is that goes to the library? Right to the right of that. Yeah, there's a small residence right now, and so that would be removed and then the parking installed.
East or west of, whatever the street is?
We're not seeing it, are we?
Well, how about from the RTD? Where is it at? It's north of RTD? Oh, okay, gotcha. I got you. So it's the little cabin between, the little cabin between the library and the church.
Correct. Yeah. Yeah. So there's 2 little houses that are just between the church and the sidewalk that goes up to the up to the Presbyterian church or over to the library.
I guess that you just finished up. Well, then you mentioned the water ponds, the flood ponds on north and south. The water ponds.
I can't hear you.
Well, you mentioned-
Speak into the microphone.
What are they called? Yeah, I'll
The
do that.
retention ponds.
Retention ponds,
Ponds?
they're in the basement or in the,
Thank you. Okay, so they drain down there. When you mentioned retention ponds, I'm looking, but that's impossible, but very good.
I didn't.
What kind of timeline do you have in mind for this? Can you just roughly, I know it's all dependent upon, many, many factors, but in your mind, do you have kind of a rough timeline and when you're hoping to have this accomplished?
Well, it depends on the approval process, of course. And I think it's probably 2 years under construction. Part of that is due to what we'll find when we do the core samples and what we'll need to use to support the building. I'm pretty sure we'll probably have to use caissons, and they'll probably have to go around 60 feet deep. So that will take a lot of time, probably a third of the time of construction. So a rough estimate, as you said, there are many different factors. Weather is one of the big ones, and will come into play, but under normal circumstances, with given some weather restrictions, I think 2 years for construction to certificate of occupancy would be normal. Debbie, your idea?
That sounds right. I would imagine that the permitting process will probably take 2 to 3 months. Safe Built's pretty quick.
Other questions? I allotted an hour for this because I thought there'd be a lot of questions from you guys.
I just had one about, you mentioned something about garage door.
Could you
protecting
get
the
a little
sidewalks.
closer to the mic, please?
Sorry about that. You mentioned a garage door protecting the sidewalk. I missed, was
Yeah,
that
where
just
the
for
arches
garage?
are? There would be glass
Ah,
doors that lift up. You've seen them in restaurants.
okay.
nowadays.
So between the arches, which would help cut down wind, because that's what I was concerned
That's
about.
the idea.
Okay,
Cut down the
great.
wind.
Okay, fantastic.
Yeah.
Okay.
Second Street or Highway 72 has sort of an artificial Venturi effect because of the dam. When they built the dam, it blocked up the wind flow. So you have a higher wind pressure down Second Street than you do either First or Third. So that's one of the reasons. The other reason, of course, is to open it up, make it feel better in the summertime. And also the charging station, the EV charging stations will be on swivels inside and hidden behind the pillars. And then when somebody comes in and wants to charge, well, that would swing out and they could avail themselves of the charger.
I'm curious who you're targeting with the apartments, what kind of populations? And if it's not too preliminary to ask, like, what kind of price ranges? Is it for luxury or affordable?
Pricing is going to depend on two things, cost of construction and what the market is at the time.
But Ron, your intent is for this to be a fair market value type housing rent, not affordable housing or workforce housing or anything like that?
No, it is workforce housing.
Oh, it is? Okay.
Yes, it's just, that's why the studios and the one bedrooms
Okay.
are weighted towards entry-level workers. Certainly, providing a variety gives people a lot more options than just having all 2 bedrooms or something like that. So it's been carefully worked on in that regard by the architects.
How many parking spaces will be across the street there by the library?
Well, it depends on a couple of things that we have considered. I think it's 9 because you have a 40-foot lot, but there's a creek runs across the rear of the property, so that might cut 1 space off. So I'd say a maximum of 8 spots unless we use parking lifts. If we had a 2-level lift, you'd then have 16 spaces. And if we had a 3-level lifts, you'd have 24 spaces.
I didn't count very quickly when I saw the blueprints, for about an hour, a couple weeks ago. Seems like we're quite short on parking with the number of bedrooms. But that
We
didn't
put as
know how-
many parking spaces as we could figure out. One of the reasons for putting the sidewalk inside the building was to be able to have perpendicular parking instead of parallel. Because if the sidewalk were normally where you'd put it, you would only be able to have parallel parking, which would give you 7 spaces.
I understand. No, the commercial part looks quite adequate. It's just the residential per the bedroom and per code. I didn't count them. I'm just questioning, but something you might review. it just seemed like a little short. So I thought you said 14 in the basement
That's
and
correct.
8 across the street. So that's,
There's 8 on the plan, and we did have discussions. It isn't in the plan now, but we can certainly put it in the next time and add parking lifts to give us either 16 across the street or 24 if we have a 3-level lift. So.
Yeah, what was the unit count total right now?
well,
For
you'd-
residential?
For residential, well, if you had,
It's 22 standard apartments and then one building manager apartment.
Okay, so 22 standard units if you don't count the manager.
Correct.
I'm sorry, I
Okay.
couldn't hear.
Yeah, 22 apartments and then additional the managers
Yeah,
for a total of
the
23.
the manager's space
23
was on the
units,
east
so like
side.
20 some odd 20. Yeah.
14, 22
14,
parking spaces
Yeah, 22 spaces.
for 3-bedroom apartment. So, yeah.
Yeah,
that's
okay.
all.
But do be aware that this is in the central business district, and right now there are no requirements to provide parking because of the moratorium for central business district. Now, that may expire before this application gets turned in, but that land falls under the central business district, and we recommended, and it was passed, that they do a moratorium that I think was recently extended. I'm not 100% sure on that, Attorney Mattson, for no parking requirements to be added for new builds. Is that still correct?
Well, I need to look at the ordinance. And I don't know if Miranda knows off the top of her head or Britt, do you know what the moratorium?
It's 40.
It's set to expire, it's Miranda, it's set to expire in October, but we did ask for a 6-month extension. And the BOT gave the verbal nod, but Attorney Mattson, we do need to draft that ordinance to bring back to the board.
Well, this is brings a lot of clarity, so thank you.
Yeah, I think it's fair that, there is a moratorium, but we also want to be aware that what will end up happening is tenants will use First and Second street parking, which will affect peak-to-peak liquors and Kathmandu and other businesses on the street. So we could put a recommendation to see if we can scramble up more spaces in the plan would be helpful.
If we used the 3-level lift, we'd have 40 spaces.
Yeah, there's 35 bedrooms between all the apartments. So that'd be more than enough.
All right, other questions?
Actually, if there is an idea of a lift, could we see some concepts of what that looks like?
Can I give you an oral concept?
Sure.
The lifts are about, or each section's about 8 feet.
Mhm.
So you'd have a 24-foot structure
For 3 levels.
for the 3 levels. And I think you'll see a lot of this in the future. There's no other way than up to do these things. So it's a busy street.
Yeah.
It's a commercial street. And I think that's the answer.
Is it a closed structure or is it scaffolding?
It's an open structure.
It's an open structure. Interesting.
So
but-
imagine, unfortunately, you weren't here when he presented a project in the past for us with the lift concept. And it's just basically like a car garage lift that
Right.
you pull onto and it lifts up, and there's another one you can pull onto, or I think if you can imagine like a double decker
Sure.
truck hauler car that there's, it goes on and it gets lifted, another one comes on, and then a third
Gotcha.
level would be. So, but it's a machine that will stand alone outside without an enclosed structure. Is that correct, Ron?
That's correct. It
Yeah.
could be enclosed.
Oh, good. Okay.
Sure.
Okay.
And we would put EV charging capacity on this thing also, because somebody's got it somewhere. If you see the projections for EV cars, there'll be, I've been watching this very closely, and next year, or at least the industry is projecting 2 million cars more. And what I've done in terms of how this is going to work, I've gone to the gas stations here in Nederland and timed how long it takes to get a tank full of gas, and the average is 8 minutes per person. So you're going to have a lot more space when it takes a half an hour to 45 minutes for a fast charge. And these are level 3 chargers. If you have a level 1 charge, that's overnight. So we would probably have some of those in the tenant parking in the basement. But your casual traveler who's going to be stopping in just to have lunch is going to want to have at least a 30 to 45 minute charge and be on his way. So
Is part of the architecture for incorporating EV chargers, do you look at the capacity for the town's electric grid to be able to handle the amount of chargers you're?
there's you're going to need 3-phase, and 3-phase runs along Beaver Creek there. And we would have to pay to have it brought. We'll need 3-phase anyway. I think there's 3-phase in back at Kathmandu, but I'm not sure.
Okay.
So don't quote me on that one, but we will definitely have to get 3-phase
Okay.
into the structure.
Ron, I don't believe, unless it happened recently, that you own the 2 parcels on the north side.
I have a partner and he owns the north side of the development. I own the south side.
Gotcha. So conditional upon the approval, that would all come together however
Yeah.
you're contracted.
Mhm.
Yeah. And then similarly, the intent of ownership upon completion, you would continue to own this with a group of investors, or the intent would be to sell it soon thereafter, or what would the ownership be afterwards?
We haven't got any planned succession of ownership at this point. We want to complete the project. We want to fill the project together. We're old college friends. We were in school together. We've done other deals together, so we're a successful partnership in other things.
Mhm.
But as far as what happens, we have both a buy and sell agreement and what happens in event of death of either one of us.
Mhm.
Neither one of us is young, so we understand there's contingencies that need to be taken care of in that regard.
Mhm.
So those are in our agreement.
Okay.
You mentioned in the presentation that the comprehensive plan had been taken into account for the design. Could you elaborate on that? I'm sorry. I was saying that in the presentation, the comprehensive plan was mentioned and had been taken into account. I was asking to have that be elaborated on.
Sure, thank you. Yeah, so some of the tenets of the 2013 comprehensive plan are focused on creating housing and parking and opportunities for financial development and providing housing for folks that are working in this area, as well as honoring the beautiful place that we live. And so one of the ways that we're encouraged about this is that it's a existing site that doesn't need to be, it's not a virgin site. There's already buildings on it. And so there's utilities coming to it already. And so one of the sustainable tenets of LEED construction is to repurpose sites instead of encouraging sprawl, which takes down trees and, takes away from our natural resources that we have. So those are probably some of the things. I think it's a three-part principle that the comprehensive plan focuses on. So anything else that?
I see there are solar panels on top of it. And is the intent to have enough solar panels to power the entire building?
That's a good question. I think that the load would probably need to be considered as far as the restaurant and the apartments and the commercial spaces. And then if there's excess energy that's being generated on the building, that will go back to the grid. So it won't be a battery supported system, but the intent is to provide for as much of the needs of the building as possible.
I was curious what impacts you anticipate on the neighbors and other businesses nearby.
Well, I think one of the advantages of having it located near the RTD is that right now, anybody who's waiting there is waiting in a pretty chilly situation and the wind tunnel comes right down towards them. And so the hope of having a sheltered area for people to come and wait and maybe grab a cup of coffee or a sandwich before they go down to work is a favorable one for anybody who's, waiting for the bus or coming up and waiting for a ride after they get up. And then the church that's across the street and the apartments, I don't think that this would be a negative impact for them because this is all, the church is occasionally occupied, and then the apartment has its own parking facilities behind and they share the parking with Calvary. And then I don't believe that there's a small telecommunications building just to the east. And so I don't think that that would have much of a impact on them. They already have some equipment that's on Mr. Mitchell's property. And so that would, I think that's going to remain. And so they won't be asked to remove that from what I understand. And then the parking and the main access to the Kathmandu Plaza and the Kathmandu restaurant is from the east and the north. And so I don't think there will be very much interaction between that. And the parking for the apartments at Kathmandu is behind the buildings, but not over on the side of where this project will be located. So, and then there's several individual residents across the street, but I don't think the only impact would be people coming up out of the parking lot and then going down First Street. So they wouldn't be, interacting with those residences.
I want to tell you, this 3D presentation and your person who's running this on the other line, this is great. This is very helpful. So I hope you're able to incorporate that when you bring this back again, because my question was about to be, how close are you going to be to the apartments above Kathmandu, and whether or not that was going to be pretty tight. But if this is accurate to scale, this kind of answers my question that there's plenty of room with them not being right on top of the other apartment.
I think it's about 50 feet.
Yeah.
Mhm. Let's see.
Yeah, Kate will give you an answer here.
We'll have an answer for Kate.
Ignoring the telecommunication building, it's almost 60 feet to the property line.
Okay.
60 feet.
60 feet to the property line.
Yep.
Yeah.
And then from the north-south leg of the plaza, it's approximately 48-ish feet to the property line. At the north side of the lot.
Okay, two last questions. The loading dock, have we spoken about that?
Yes, we have. It's on the east side. All of the utilities and the loading are up from the south on First Street. None of the loading activity will be done from 72, just too much traffic, too much chance of an accident. So that's been planned for trash removal, recycling removal, cardboard crushing, and we will probably have on-site cardboard crushers so that we can do that. And there's a jog, as you see in the building, on the north, because the north portion of the property has half of a lot larger than the south side. And there's an easement on the south property for the phone company because they inadvertently put their cable on my property. So I gave them an easement several years ago, and that's within the easement that we need anyway. For their,
So that building will stay there then?
oh yes,
Yeah,
that building services a huge area. So that's going to be there. So when we come back with a proposal, we'll definitely put in the parking lift with the 3 levels because that'll give us 40 spaces, 20, and then there'll be, count the 20 on city property would be 60. So overall for the project, counting both the private spaces of 40 and the public spaces of 20, that's approximately the parking that we'll have.
And I mean, there's the lift structure, since it's so close to the library, I would consider it.
I'm sorry?
I would consider an enclosed design and maybe an open design, depending. I just have a feeling like with it being right next to the library, people aren't going to want an open design.
I'm planning on talking to the library board and taking this
Yeah.
proposal to them
That's a great idea.
before we bring it back to you.
Great idea.
I'm not sure if you caught him. He was talking about the noise of it. Maybe you might need to enclose it because the noise might be too much for the library of the operation of the lift.
I'll do some research on that and
Okay.
see what it takes.
Well, here's my final, this is sort of an ask. Don't know how many years ago, it was 10 years ago, whenever the Kathmandu Plaza went in. They were going to have access on the north side of their property and possibly, for loading and unloading and being able to go all the way around the plaza. They came back after being built, or certainly the explanation that I received after they said, oh, sure, we'll be glad to do that was, the planning commission received, was that the property fence and a building right there was actually not on their property. So there wasn't enough room to do that. I'm asking Ron, is there any way you could work to bring this up right at the conceptual idea, possibly to work with the Kathmandu Plaza to see if there's some way that they could at least get some kind of access there so they could use some of their loading there? Because obviously in the planning, it's woefully inadequate. So that,
What I see we could do is pretty simple. We give each other a mutual easement. And we take down the fence that goes right through the center where you'd like to have access. And I give her an easement on my property and she gives me an easement on her property. Then I think you'd have about 18 feet.
well, you're aware of what I
Kate,
was,
can you tell us what the distance is from the east side of the building on the northeast corner of the building we propose and the Kathmandu building? What's the distance between those two buildings?
Were you talking that their access was from the south or the north?
it's the northwest corner of the plaza.
Of the plaza. Okay. Yep.
Ron, I would say anywhere between 20 and 22 feet.
That's adequate to put a driveway in there.
Well, thank you, Robert. You're familiar with the issue I was bringing up then, I suppose.
Absolutely. I'm sure.
Okay. Well,
I will approach Kathmandu before we come back to you and see if we can do a mutual easement to give us a 20-foot driveway. And we could probably have to put a curb in on each side just to protect the building. And the
sure.
downspouts probably extend a foot or so out from the building.
That would be super, Ron. Thank you.
Actually, I think we could really solve a drainage problem by doing that too, because the water off the northwest corner of Kathmandu's roof goes right out into Highway 72 and creates a huge puddle because there's a dip right in front of the art gallery there, and it ices over every winter because that dip is about 4 inches deep. We could run the water into the new easement, into the drain system, send it south and clear up a lot of that drainage problem. That's one of the reasons we drained this entire building at the Amsterdam to the south, was because of the mess that's created on the north in that dip in Highway 72. And it doesn't look like CDOT is going to come around anytime soon and fix it. Okay, so we will come back with additional parking with lifts. We'll come back with hopefully an easement to do this driveway. And is there something else that somebody else suggested that we anticipate there? I did get some comments from the public already. And one of the things that was requested was a roof patio for the tenants to have a place to go hang out. That would mean that you'd have activity. Are you shaking your head, Jim? I'm sorry.
I just see that might be tough with the solar panels, with the coverage you got.
Oh, we'd have to remove about a third of the solar panels, but anyway, that was the request. And also, the other request was that some of the windows be larger. And certainly, I don't know, Kate, could you turn around to give us a view of the west side of the building? Oh, there it is. The ground level commercial spaces would have larger than average glass, but I think they have to have at least 18 inches of wall so that it's safer. Bicycles don't run into it and things like that. Okay, those are 4 things that I hear you're saying that you'd like us to bring back. Is that correct?
To consider. We're not directing you to do anything, to
No.
consider. Yes.
I understand.
Do you mind if I just?
Go ahead.
So one thing, because the rooftop has been something that that Mr. Mitchell had wanted to look at from the beginning, and one thing that we were noticing is where the parapet wall is right up at just slightly under that 35-foot height limit, and if you had a access to the roof, which we could certainly provide, there would need to be a penthouse that would exceed the height limit of 35 feet to get up to the rooftop. So we were trying to stay within the zoning, but if that's something that the town would consider just for that small area, the penthouse doesn't take up very much space. It could just be, a continuation of the north and the south stairwells, and the stair and the elevator could go up there, and it would need to be about 8 to 9 feet above the roof surface. So we would be exceeding the height limit by about 4 or 5 feet. So if it's something that's desirable and the town wants, we would need to have permission to go above that height limit by several feet in 2 very small locations.
Couple quick questions about that.
Well,
were
we'd
people-
also need a handrail around the top too, at least 4-foot level.
Sure, yeah. Were people asking about rooftop for the restaurant or for?
No, for the
tenant?
tenants.
Okay, and would this
There would be no restaurant service up there.
And this would be a shared open space for all tenants or just for certain units that have that?
It could be both.
Okay. Well, I guess one of the things I would be curious about is if our goal as a town is to provide affordable housing, this would bring the cost up, wouldn't it?
Yes, it would,
Yeah.
of course. Putting a patio up there would,
Yeah.
but I also think that it would be very desirable for people to have a semi-public space to congregate and hang out and not be forced to open their own apartments. And we don't have much public space other than the restaurant and the sidewalks. So if it.
This be a design option that you're considering? Like you present both?
We
options?
talked about it, and there seems to be such a, how do I put it? Tenacity of opinion that exceeding the height limit is sinful. That you have a height limit that was put in
Sure.
years before modern construction techniques and needs arrived. So trying to pack everything you need, fire sprinkler systems, ducting, all of that stuff into 35 feet for 3 stories is very difficult. So
Yeah.
I would prefer to have forced air heating, but we can't do that really because of the height limit, which forces us to use a pumped fluid system for heating. That's just what we face in terms. So we were afraid
Yeah.
to
I would
make
just be
that proposal.
curious what, an open space with furniture and everything on a large roof like that, where the wind is probably the strongest in town, how that would behave. Just, I have no idea. I'm curious.
You wouldn't be using it in the wintertime. Summer, it'd be a summer patio for sure.
All right, Ron. Well, thank you so much for bringing this before us today. I was going to put a comment in there and ask you about if you've gotten any comment from the neighbors, but I started thinking about where that lot is. And as far as height, because you're right, that people will definitely come out and say, we don't want a building that height blocking our view. But luckily, I don't think you have too many residences right around where that building's going to be, that would be an issue. You'll probably still have some people come out and say they don't want a building that tall, but I mean, will it be the same height currently as Kathmandu is, or a little taller?
The Kathmandu restaurant is 35 feet within a half an inch, and I can attest to that because we drew it. And I don't know about the Kathmandu Plaza. When I looked at the drawings, it looks like it's maybe 22 feet or something. Mark would probably be able to answer that because he has the drawings for that, but I don't think it's anywhere close to 35 feet.
Okay, so this representation you have where they're kind of looking like the same height is not actually accurate.
Well, it undulates. So that was the Kathmandu Plaza undulates, and so it's got that tall crown piece that's facing at the corner where the liquor store is, and that's the tallest part, and that's probably real close to, it's over 30 feet, I'm pretty sure, but some of the lower parts are a little bit shorter than that. So, yeah, so that was just that representation is to kind of give you an idea of what just the footprint looks like and such, and it doesn't represent the Kathmandu apartment, which is a hipped roof, but that is 35 feet, so.
All right, Ron, well then I'll revise what I just said and say that it probably would be worthwhile for you to check with those residences that's view are going to, there's apartments that face your building on the second floor of Kathmandu that will be impacted by the height of your building. So it would be, one of the things that will be asked will be, what's the neighbors have to say about it. So it'd be worthwhile for you to find that out.
Okay, we'll do that. So that's 6 things that you'd like to see come forward.
Just suggestions.
We're hearing your suggestions.
And I might have another item for consideration. And I think in the presentation, you said that an attempt would be made to some degree possible, match the aesthetics of the historical character of Nederland. Did I hear that? Because I wasn't sure. Yeah.
Yeah, the stone and the arches are reminiscent of the curved barn that is the history museum that's adjacent to the roundabout. And then the lap siding is very prevalent in many of the buildings that are in the central business district, particularly down on First Street. And the parapet walls are found on some of the other buildings. Like if you think about the pizza CrossFit, they have that parapet wall, and then there's a sloped roof behind it. So the store, the storefronts of some of those buildings on First Street have those parapet fronts.
Yeah, great. An idea is that when you come back to us to include some of those details in the renderings if possible. I know this is preliminary in architectural software, but I think that would lend a great deal of appeal to see what it might actually look like.
Okay, yeah, and I think the windows are in particular we were trying to follow the design standards. They request large storefront windows down on the first level on the First Street, and then they like the double hung or the single hung on the second and the third levels. And so if you look at some of the buildings on downtown, like the smokehouse and such, they have the single and double hung windows.
Great.
Thank you. That actually then you brought up a good point then. how close would you say, I know that there's always a little adjustment and tweaking, but how close is this rendering to what you see the final product being? Is this an 80%, 90% solution right now, 95? What do you think?
Well, I think Mr. Mitchell might be able to answer that. I think that if we were looking at the surrounding neighborhood, most of those buildings, Calvary Chapel, and then the apartment, the county apartment across the
King
street,
Village, yeah.
that they have a lot of the lap siding. And so I think we would be pretty pleased if we were able to stick with that siding just because it's specifically required in the standards from the town.
I guess I'm trying to get at is, as you're showing us here
Mhm.
with the colors and the design, is this pretty close to what you're trying to build, or are you thinking there's going to be significant modifications based on feedback?
Well, I guess we could definitely consider some of the feedback, but I think that this was probably our first attempt at what we think would be complementary to the and compatible with the neighborhood.
Okay, that's all I was trying to get out of you, whether or not this is pretty close to what you're looking at for a final design.
It would be very useful to have some high definition renderings, if possible. Just an idea.
Yeah, you bet.
All right, guys, I appreciate it. Your presentation. You kept to our time, and we were the ones that took up a lot of your time. So thank you so much, Mr. Mitchell, for coming and presenting this informational possible project that could be coming in the near future. I think that certainly it addresses some of the issues in our comp plan, having additional housing, of 23 units. I think I appreciate that you're making efforts to try and improve the housing situation in our town.
And we thank you for squeezing us in on the agenda. That was very nice of you to do that. Thank you.
No problem. Okay, moving on with the agenda. Our next item is going to be address sign codes, 7.1, the aim for address sign codes. Are you going to?
That's me.
Okay, please go ahead.
Yeah. So yes, this was originally brought to town staff's attention by Fire Marshal Andrew Jocelyn and the fire department. They have been working on efforts to get the residents in the district to ensure their signs are posted and posted correctly, so they are able to see them. Marshal Jocelyn has provided a summary of the code that pertains to the address signs in Netherlands Fire District. I will just go a little bit beyond that. Marshal Jocelyn explained that the current code language is unclear, outdated, references the Netherlands Fire Department, volunteer fire department actually, which no longer exists, and does not require compliance with the recommendations made in the IFC and by Boulder County. So Marshal Jocelyn is requesting that the town change the language in the Netherlands Municipal Code 18-104 as follows. So there's a picture that you will see in the aim, and there's also a flyer that I've attached. It is a reflective sign, 4-inch minimum characters, 1/2-inch minimum stroke, white lettering, green background, attached to a metal T-post or non-combustible approved means, 4 to 6 feet above the grade of the road, legible from both directions of traffic, some sort of exception for mounting directly on the residence or the building within an X number of feet of the public way. Staff is recommending that we work with the Netherlands Fire Department to update town's code for address signs. Something to mention is it would kind of work as a grandfathering in. If your signs are updated to the current code, Fire Marshal Jocelyn is really good about working with the town in regards to if it does fit our code, we're not going to make you change it. But some of these new buildings and some of these addresses do not have signs posted. So they would like that visual clarity so the fire department is able to find them. Kind of some next steps for us would be the fire department would like to work with staff to update the section of code to coordinate with the Nederland Fire Department efforts to get proper addressing for emergency services. Marshall Jocelyn is proposing that the town allows signs to exist, which I mentioned before. And yeah, so I do have Fire Marshal Jocelyn on to answer questions. I also can answer questions as well. I will say he has a lot of information, so definitely ask him all the questions you can. We are asking the board, do you approve the staff and Marshal Jocelyn moving forward with updating this portion of code? Do you have any suggestions or on some sort of exceptions for mounting directly onto the residence or the building within an X number of feet in the public way?
Can I talk real quick before we get
Sure, go ahead. Please
sorry.
introduce
This is
yourself.
Marshal Jocelyn.
Yeah.
Yeah. Hi, my name's Andrew. I'm the fire marshal for the Nederland Fire Protection District. Thanks for allowing me on. I apologize. I'm on the road right now, and so bear with me. It's been a long travel day. So yeah, so the referencing to the X feet from the road, I actually did some digging into this, and I felt like a more appropriate number would be 30 feet. And the reasoning behind 30 feet is that if the home is properly mitigated, that 30-foot section should be clear of trees that would be blocking a sign that is on a residence or a building, et cetera, because of that mitigation work that's done. So I think the 30-foot number is a really good one, and it ties into WUI code, and it ties into mitigation efforts. And now new construction is required to do a mitigation plan, so they should be following that 30-foot measure.
Okay, this is Vice Chair Reese, and I just had a comment on that because I was thinking about this as I read through this. You know, we have all varying size lots and properties in town, and my house is properly mitigated, but that doesn't mean that I don't have trees out. You know, the mitigation doesn't extend, it's around the house. It's not around out by the driveway or near the road. So the 30-foot mitigation, you know, that you're talking about, I don't know that that applies to some driveways. Some people have very long driveways, and I don't know. Do you have any feedback on that?
Yeah, absolutely. Thanks for your comment. This would be for if the mounting of the sign on the residence or the building was within 30 feet of the public way.
Okay, I see. I misunderstood. Thank you. And do we have questions for Britt or Fire Marshal Andrews, Jocelyn, excuse me, about this? Okay, I will open it up to public comment on that. If there's anybody online or here in the room that you would have 3 minutes, please identify yourself if you would like to speak on this issue. The issue is whether or not we would update the municipal sign code. And I believe, I don't know if it got glossed over, but the main thing is it's a safety issue so that the fire department can find these addresses quickly and not, you know, have somebody possibly lose their life or a building burned down because they're trying to find a residence. Is that correct, sir?
Yes, sir. And if you wouldn't mind, I'd like to comment on that just for a moment before we open it up to public comment.
Sure, please do.
Yeah, we've had multiple calls this year where we were unable to find residences while CPR was in progress. And we don't think in these instances that it changed the outcome of the call per se, but it definitely really opened up our eyes to, man, we've got a reoccurring issue where our first responders, 2 o'clock in the morning, trying to find somebody's house. They know somebody's laying on the floor, not breathing, heart's not working. And it's, you know, it really deters from our ability to get in and try and make a change for somebody. And that's kind of what spurred this communication within the department. And then we decided, well, what does the code say? And the nice thing about the changes that we're putting forward is that it doesn't require a change in the fire code. It just requires municipal code to kind of coincide with the updates. And if you read the in section 18104, section 1C, the addressing system used by the town shall be that adopted by the Nederland Volunteer Department. And I think what that's saying is that regardless of the municipal code, as long as the fire department is updates to the address.
Marshall, hey, Marshall Jocelyn, we're getting about every third word from you. Are you in a place that you can get to that we can hear you a little better, Marshall Jocelyn? We're hearing about every third word from you.
Yeah, just 1 second, please. Sorry about that. Is that any better?
Yes, much better. We're hearing you.
Okay, sorry about that. So yeah, I'm not sure where you could hear or could not hear. I apologize for that, but the town code currently says that the addressing system used by the town shall be that adopted by the fire department. But we just want to make sure that we're keeping you guys informed with the efforts that we're trying to make and why we're trying to make those decisions. And we certainly appreciate any of your work towards a common goal. So, yeah.
Okay, thanks very much. Is there any public comment? Public comment on this issue, on somebody have strong feelings about adopting changes to address signage? Please step forward and give us your name and address. You'll have 3 minutes.
Kayla Evans, 1250 Eldora Road. Thank you, Fire Marshal, for what you're proposing here. I think it's really important also. I know, Jim, there's a lot of people in planning board that live in town, but there are a lot of people in Nederland that live outside of town that have entrances to their properties with big stone, whatever. And the idea of putting a green sticker on that is not, they're going to shy away from that. But there does need to be something standardized. Maybe this is an augmentation of what they already have as their address. There are people that really don't want anybody to know what their address is, and that is problematic. But I do value, we had somebody have a heart attack on our floor 2 years ago, and thank goodness they all knew where to come. But if we hadn't had signage and they didn't know, I'm not sure he would still be here. So those things are really, really important. And maybe there's a way of compromising to let people still have their individuality with their thing that they've put out, whether it's a wagon wheel or a big piece of rock or something, but have the signage that tells the fire department, police department where to go. That's not halfway down your driveway, that maybe is right on the road. That's the cutoff to your property, and make it all kind of the same so that they have a map that they can use that's standardized for everybody. So I would agree that I think this is really important, and the less intrusive you can make them, but the more informational, the better. Happy medium, hopefully. Thank you.
Thank you. Appreciate that. Anybody online that would like to comment on this, please make yourself known. And if you're trying to speak right now, you're muted and we're not hearing you. Okay, hearing none, then I'll bring it back to the Planning Commission and close public comment on this issue. As I went over this issue, and it doesn't matter to me who responds, whether it's you, Britt, or Marshall Jocelyn. I thought I saw in there that the issue was we don't need it all to be this green sign that you have in the example. If there is an acceptable address sign already in place that meets these requirements of 4 inches high and 1/2 inch wide and reflective. Is that accurate?
Do you mind if I comment?
Go ahead.
This is Fire Marshal Jocelyn. Yeah. I was going to go even a step beyond that and say that as long as, I know the terminology grandfathered in isn't appropriate, but as long as they meet the current existing code before the changes, that they wouldn't need to meet the new, it would be voluntary. It wouldn't be like you're forced to make that change. So the folks that we're looking forward to include with this initial effort are people who aren't currently meeting the current code and folks that are building new construction or replacing existing signs.
Okay. Is there a method of evaluating current address signs? Will that just be on the owner to be sure that that is correct? Or will the fire department or Safe Built or somebody be going around and checking compliance on these?
That's an excellent issue or comment. We currently, the fire code, we don't necessarily go to homes and tell people that they have to do stuff. That's not what
You're
fire
fading
code
out on
is.
us again,
That's
Marshall
more
Joshua.
of when someone. Sorry, give me a second. Just. Can you hear me now?
Yep.
I'm so sorry.
Yes.
Okay. What we're. Oh, sorry. Hold on a second. Okay. Now can you hear me?
Yes.
Okay. No, we're not going to go around and knock on doors. But what it would be is if we run a call or we'll do some public education, some outreach, et cetera, to make people aware that we're having a drive and initiative to do it. But if we do run calls, et cetera, and we run into issues, now we have a solution for them in place. We're even in the very early part of discussing working with local businesses and an online retailer who will stock something at a low price that meets the requirements that we're looking for, so that we have a means of people doing that and getting it themselves. And then we're even talking about offering services to folks who don't have tools, are uncomfortable, or have a physical inability to put the sign in place to go out and do it for them.
That would be excellent. There certainly are seniors in our community that, and I don't know if the fire department has to take that on alone. Certainly, my church does a lot of volunteer work, and I think we could probably organize some local volunteers to kind of help as calls come into town hall with that kind of stuff. But that you followed up great, because that just kind of answered my question. Who was the cost going to fall on? And do you have an idea how much these signs would cost and how they could be got? So you're still trying to figure that out?
Our current estimate and what we've been looking at is roughly between $25 and $30 for the sign. And that's a 7 to 10 year rated 3M reflected manufactured sign. So there might be something that has a lower warranty on them. There might be a cheaper solution, other means, but we're even looking at grants that could help subsidize some of the cost as well.
Okay, thanks very much. Does anybody else have questions for Marshall Jocelyn? All right. Thanks. We'll close the discussion on this. And I'm a little unclear. Are we looking for a vote on this or are you just?
No, we're just looking for kind of, is it okay to start working with the fire department on this? I guess is kind of how that was worded. I don't know if Miranda wants to speak further on that.
Yeah, I guess it's Miranda. We're just maybe looking for like a nod of four of sorts that the planning commission would like to see town staff work on this ordinance with Attorney Madsen, and then we would bring it back for your review.
Anybody opposed?
As a former pizza delivery driver, I approve. Very helpful.
I just want to comment. Actually, maybe one of the most frustrating 15 minutes I ever sat on the planning commission. Sorry, I have to get on my pulpit though. I can't believe that's even a discussion item. We should just be recommending, if it's already code to do what the fire department says to do, then, you know, this is unbelievable. These things, that little sign there, you know, took me 15 minutes, $30, you said, if it's that. You know, you spend $10,000 trying to keep my body healthy. I spend $2,000 a year just insuring my house. I mean, it's absolutely ridiculous. Of course we should do this.
Okay.
Thank you for my venting.
I'll put you down as in favor.
But we, you know, it should even been a discussion. It just should have been go for it.
I've got one more question for Britt. So number 2, it says the town shall post all such signs at the expense of the town. Is that the current code or that's what is being proposed, and what does that all look like?
That is actually the current code, correct, Miranda?
I have to pull it up. I don't have it right in front of me.
It
I
is
can
town-
I
it
can
is,
read it
yeah.
to you. Yes.
It
Yeah.
is.
So does
Yeah.
that mean I could go to town hall and ask for an address sign and get one for free?
That's not right.
See you
I don't
tomorrow,
think I can do
Miranda.
Well, what I would say is that we don't have a budget for that.
Yeah.
So that will be something that I'm guessing you guys are going to look at.
Yeah, I was just gonna say, I think we'd like to take a further look into that component as well in this proposed modification.
Okay, well, we approve of doing this. This seems all in the efforts to save lives, and we're all in favor of that. So yes, we would like you to pursue that. And so we'll move on to the next item, which is 7.2, the fence code, consideration of updating the municipal fence code. And who's presenting that?
That will be me. So this is still going to be a discussion item based on the questions that came before us last meeting. So summary, Commissioner Chris Rivera volunteered to champion the research of why RIC changed its fence height to allow to be built to 7 feet without a building permit. Possible changes, fence height in Nederland Municipal Code, and clarification for where the fence height should be measured from. Based on the discussion from the March 15th, 2023 meeting, it was determined that the fence height would change to 7 feet in order to align with the International Building Code, and that the following language would be added to the code related to fence height measurement with that diagram. At that meeting, there was also some requested follow-up. One of them being who is allowed to build to 8 feet under Section B. This is in regards to the junkyards. Commissioner Rivera recommends that both property owners on the shared property boundaries be allowed to build to 8 feet. So either the person who has the junkyard or the person beside them. We have listed our current code language there. So it would just be changing that to make it more clear for town staff. Another was, should there be regulations about fence building materials? Commissioner Rivera found that there was no recommended fence materials in the IBC documentation. Town staff contacted Marshall Jocelyn for his feedback on the building material. While he noted that fire-resistant building material would be costly, he recommended allowing traditional fence materials within the following exceptions. The section that attaches to any structure, shed, garage, house, etc., or comes within a certain amount of feet, X number of feet, of the structure must be made of non-combustible or ignition-resistant materials. No grass, trees, shrubs, or vegetation within 3 feet of either side of the fence, gravel, dirt. No latticing allowed. And fence design that allows a greater airflow. So those were some of Fire Marshal Jocelyn's recommendations. The other question that came before the team was, should the fence height in the CBD be changed from 4 feet to 7 feet? Commissioner Rivera recommends updating Section C to add the language which would specify that any fence built within the CBD would have to conform to Section B or be built to spec as per Section C. We have what the current code language is there. So it's Commissioner Herring had brought up that we town staff couldn't find out why it was 4 feet originally, and think across the board it should be bumped up to that 7. Setting fine amounts. Commissioner Rivera found this change would require some additional work with the committee and possibly the Board of Trustees to approve a fee schedule amendment. Commissioner Rivera recommends the language in the current code remains. Next steps for this situation would be, since the fence code is in Chapter 16, there needs to be a public hearing set before the PC. We would have to schedule the public hearing from May 22nd, 2023. At that meeting, the PC will be presented with the revised ordinance. Questions before the board? Does the PC agree with Commissioner Rivera's recommendation that both parties are allowed to build to 8 feet? Does the PC agree with the recommendations from Marshall Jocelyn about the exceptions for allowing buildable material for fences? If so, does the PC want those guidelines codified or just to be considered as a recommendation that town staff can communicate to builders by providing a flyer of some sort? Does the PC agree with Commissioner Rivera's recommendation for the CBD fence height? And does the PC agree with Commissioner Rivera's recommendation not to revise the code language as it relates to the fine amounts? Last question before the board again is, do you have any additional comments, questions, recommendation before we bring the ordinance back to the board?
Okay, we'll first do questions of staff by the Planning Commission. So if you have questions of either Britt or Commissioner Rivera, please ask them now. Really? All right, I have several. So as I was reading this, I thought it was kind of worded a little confusing because under Section B, I thought 8 foot was supposed to be a screening fence for unsightly junk and stuff like that.
It's specifically junkyards, outdoor storage yards, and other legally existing uses involving the outside storage of machinery, equipment, materials, and automobiles.
Okay.
So that's when you should build, or they typically would want to build up to 8 feet, and that would be fine without an SRU. Okay.
I just, as it says here, do we agree with allowing both parties to build to 8 feet under Section B? It would be great if that was just a little clarified that is not the standard building height that any.
Well, that subsection is just for those scenarios. So we wanted to make it clear that either party could build that height.
Okay. I'm just saying that not everybody's going to know what Section B means. And that when I first read this, I thought that you were proposing that everybody could build to 8 foot.
Well, no, it reads specifically. I mean, B says a fence exceeding 6 feet in height may be constructed for the purposes of XYZ. Yeah.
Okay.
So it's, the main first section talks about a regular fence height, and then section B is for those purposes.
I guess the
You can
confusion is
exceed it
because it's
up
not
to
in
8.
there.
See the code, then it'll make sense.
Yeah.
It's right there.
Which the code is,
It's 95. at
and the
very
code
bottom.
was attached.
Yeah,
to
it's
the
on.
Draft code.
I see. I was just reading the name. My fault. Okay.
That's okay. It's yeah. So right after that diagram, then it says who is allowed to build up to 8 feet under section B. Then it has current code language, and then you can read that paragraph, how it's written there, laid out there.
Oh, okay. Who would be the one to determine whether or not the junk is
Well, that's
sufficient to be
That's what makes this change even easier for town staff is whoever's on that property line to those type of, because those businesses wouldn't be there without approval anyway.
Yeah.
So the town has established and let a junkyard or a machinery or an equipment company. So therefore, either owner on that property line can build to 8 feet.
Okay. So this isn't just, I've got a neighbor who's got 3 cars up on blocks over here
No.
that I don't want to see.
It has to be an approved,
Okay.
business.
Okay.
We don't have any of that in Old Town or anything.
No,
Yeah.
no, not at all. And so are we then just not, it's already a done deal that the 7 foot is going to be the standard height for residential?
Based on the feedback
fences?
from last month, yeah, everybody was basically like, let's just keep it simple. And so instead of doing like 6 with a variance of a foot, then we just said, let's just make it 7 and keep it simple.
Okay. And then in the CBD, changing the fence height from 4 to 7 feet,
Mhm.
while I agree that would be great if you were trying to screen off dumpsters or something like that, I wonder if that couldn't possibly be that it would then screen off another business right next to you and provide some kind of impediment site if I built a fence along the front of my property.
Yeah. So what my recommendation was to keep the existing language of 4 feet, because it's specifically 4 feet within 15 feet of the road.
Okay.
And it is for the purposes of blocking dumpsters and various stuff in the back of a building or side of a building along some of our roads. So the only thing I added there was with the exception of section B. So if we have a machinery company or like theoretically AmGas, could have a larger fence that blocks the view to kind of hide it, in our CBD. And so I just worded it so that for those scenarios, then you can build up to 8 feet, which most likely is not going to happen. But that allows us the kind of flexibility to say, okay, the standard height in the CBD is 4 feet within 15 feet of a road, or you can build up for the purposes of a junkyard, machinery, automotive, etc.
Okay. And then I wonder, I'm not saying tonight, because I'm going to guess that people don't have cost that they could tell us what they think it might cost to have these fire resistant fences.
Yeah.
But I wonder if in the future, before we look at actually sending a change, it would be possible to get some feedback from a builder or somebody, what's the actual impact? I mean, if this adds $10,000 to the cost of building a fence on a new build, and I get it that it says it's only where it's adjacent to the building and all that stuff, but there's some other financial implications that I don't know. I wonder if after the fact,
Sure.
after it's passed and people realize it, and then suddenly they start getting some code violations because they built a standard wood fence, and
Yeah.
then they find out, oh my God, I got to rip this down and build one. I'm looking at a Trex deck right now, and the cost is about 5 times what it costs
Sure.
for actual wood. So
Yeah, the way I kind of looked at that topic was the original reason this was brought about was because we weren't in alignment with the building code standards. So I felt like this was kind of out of scope or scope creep, throwing in additional stuff. I think it's good input. I think it would be really valuable to have as an informational sheet that town staff could provide when someone is building to say, hey, this is fire mitigation. We live in a, dangerous area. So, these are some recommendations. You should look into this. But as far as my recommendations for changing the code, I felt like that's a little beyond what this was originally about. So I kind of recommended that we make it a recommendation, really.
Okay.
And Marshall Jocelyn is still on. If you have any questions about his recommendations or anything about that. So just to let you know, he's still on.
I will actually, in the interest of time, and I'll hold that because we'll see this again before there's any official changes. And I will, at this time, if there's no other comments from the.
Well, just to be clear, whatever we say, if we all agree this is good the way it is, the plan is to post this and then vote on it next month. So, I mean, we can't vote for changes at that time, but that's the intent, really. So just so you know.
First of all, Chris, thank you very much. You've really jumped into this, so I think you've done a fantastic job. Thank you.
Thank you.
So the fire part, the special material and stuff, that is not in the building code.
It's
That
not
would
in the
be
IPC, and I didn't add it as a change.
Right. Just wanted to make sure.
Yep, that's right.
That code now would be additional.
Correct.
Okay.
Just recommended.
Yeah,
Just recommended.
that was just town staff reaching out in kind of in jointly.
Yeah, Commissioner Glasser brought it up, and we wanted to look into it and see is there any precedent? Does anybody make recommendations or use something different, in their code? And we didn't find anything. So
Well, and there are people that will come and accept that recommendation sheet from town hall, and cost is not an issue for them.
Yeah, absolutely.
That's not everybody, but there are people that will build the top of the line best thing. And so I agree that that's good to have those recommendations. Any other comments from before we open it up to public comment? Okay. If there is anybody in the public that would like to speak on the possible changes for fence code, now would be the time. Please make yourself known either online or here in the room.
Kathleen Chippa has her hand raised, but my assumption is she would need to call in, which I know takes a little bit of time.
Well, go ahead, Kathleen, call in. After this, we will move on to the 3 Mile Plan, and hopefully we will get out here before 11.
Hello?
Hi, please identify yourself, and you will have 3 minutes.
Are we on public comment for fences?
Yes.
Kathleen Chippai, 32-year resident, East Magnolia, 20-year business owner. I just want to thank Chris for recommending that everyone be treated under the equal laws. It is the United States of America. I was rather upset when the people building the condos over by Little Bear were told that they had to apply for a variance and pay $1,500 and go through a bunch of commissions because apparently Knotted Root was told they could build an 8-foot fence, and they were told they weren't even allowed to build a 7-foot fence, even though the International Building Code was adopted, and that's what it says. But I don't like this repeating of the language. The only reason that these changes are needed to be made is because the town staff has poor interpretation skills of what the law says. But if we start with the basics of everyone is ruled by the same laws, of course the adjacent neighbor's property to anyone's property has the right to build an 8-foot fence if it meets the qualifications. And I was a little stunned. It doesn't specify 8-foot only for lawful businesses that store things. It doesn't say businesses at all. It says junkyards or this or that, but it also includes automobiles. The average person can have an automobile. And a 7-foot fence, I like the change from 6 to 7 because we did adopt the International Building Code, and that's what it says. Without a permit, the 8-foot, of course, applies to everybody, every human being. It did before this change. I don't even think we need to add this sentence. I think it's repetitive and wordy in a bad way. And it shows that we don't even acknowledge we live in the United States of America, where everyone has the same rights and we're all ruled by the same language in the code. So I would suggest taking out the added language about adjacent properties. Any single property that meets the specifications of wanting to screen anyone else's junk has the right to in the current reading of the code. So that's everything else. I appreciate the specifications on the one property's lower and one property's higher, but again, that was already abundantly clear. If you're putting a fence on your property, it's the height of your property. So that's where I'm at with that. And I don't agree that about the changes in the central business district with the fencing. And I don't agree that it should be mandated that anybody can, what do you call it? Oh, I'm sorry, I just lost my train of thought. So I don't agree that the central business district should be under the same regulations, quite honestly, unless they're protecting, covering up a dumpster, which is not a problem in Nederland. So there's one other thing I wanted to say, but I forget what it is. I forget what the other thing is, and my computer is not
up.
for me. So thank
Okay,
you.
thank you for your feedback. We appreciate that. Okay, any other public comment online? Please make yourself known, introduce yourself, name and address if you would like to speak. Okay, hearing none, we'll close the public comment portion of this and bring it back to the Planning Commission. At this time, is there any other questions before we agree with the recommendations here? No? Okay. Personally, I think everything, I also thank you for taking this on because as somebody who did the parking stuff, I know that sometimes these kinds balloon into a lot of work. And
Also,
so
Brittany and Miranda deserve a lot of thanks too. They helped out a lot. Appreciate y'all.
yes, our town staff is definitely invaluable and do the lion's share of the work for all of us. So well said. So at this time, we don't need to vote on it. We just, I think we're all, is there anybody opposed to agreeing with all of these recommendations? Now would be the time to say so. Okay, I also agree with all of this, and I appreciate that you did not try to change the fine amounts also because that's where it gets a little sticky. So the tables on that. So, okay, thank you. And we'll close this issue unless there's anything else you have, Britt.
I do not, and Miranda will be presenting the 3-mile plan.
All right, we'll move on to that section. And Miranda, please go ahead when you're ready.
All right. So the last discussion item before you is the 3-mile plan. So just a little context here. On December 20th, 2022, the Board of Trustees adopted Ordinance 834, which was a repeal and replace for Chapter 16 addressing annexation petitions. The next step in the process is to develop a 3-mile plan. What is before you is a draft plan, and it really is just that. It is just a draft that includes some of the required language regarding a 3-mile plan, and it is pretty bare bones, but it's supposed to just create a framework for the Planning Commission to then build off of as you so choose. We did ask Lindsay Danforth, who's a GIS administrator, to support us with drawing a 3-mile boundary, again, for illustrative purposes, to show you which parcels fall within the boundary. And then she actually built us an interactive map so you could really see exactly what parcels fall there. I think it's really important to note as we enter into any of these discussions about the 3-mile that the plan does not assume, propose, or guarantee that the Board of Trustees will approve to annex any property within the 3 miles of the town boundaries. It's really a requirement to have a 3-mile plan under Colorado Revised Statute. And that is again why this is coming before you as kind of the first of what I assume will be many discussions about the 3-mile plan. You've received a lot of public comment about the 3-mile plan over the last couple of days. So a couple other things I just want to add is that you could choose to kind of hold a 3-mile plan and offer the recommendation to the Board of Trustees to incorporate it as a part of the comprehensive plan, or you could do it as a separate document. The town does not have funding to secure kind of a third-party consultant just for the 3-mile plan. So if that's a desire, then staff recommendation is to let this 3-mile plan be a part of the comprehensive plan update. Otherwise, we would be working on it with the Planning Commission administratively. And of course, Attorney Madsen is here to answer any legal questions regarding the 3-mile plan.
Okay, thanks very much. Questions by the commissioners?
This ArcGIS illustration, so it's 3 miles as the crow flies, not as property or town boundaries it is.
So
Is that
she
what
drew
that
it
blue
from
line
3
is?
miles from outside the town boundaries.
Okay, so it's okay. Wow.
If you look at the map, it's a little bit cleaner to see that 3 miles from the actual boundaries of town. And then again, that GIS, the extra doc or the online version is just to show the exact parcels.
But the GIS has that blue circle around. Is that the extent of it? Is that
Yep,
right?
that's the same circle that you would see on this PDF. It's a little bit maybe more like elementary drawn, but
Right.
it is the same circle.
Okay.
Okay. I will just ask, certainly after reading the public comment, there's lots of things that need to be developed in this. I want to reiterate for anybody who might be listening online that just because we're looking at a 3-mile plan and possible annexation plans, again, that does not mean the town is intending on trying to bring any outside, to initiate bringing outside land into our boundaries. This is something that is initiated by the property owners from outside of town, not us trying to go and then see some valuable some valuable property that we want to incorporate for tax purposes or any other reason. So at this time, do you have anything to add, Attorney Madsen?
No, I don't have anything to add. I mean, well, I said no, and then I'm going to say something, but, so yes, I do have something to add, and that is that it is a requirement of state statute. The state statute requires prior to completion of any annexation within the 3-mile area, the municipality shall have in place a plan for that area that generally describes, and then it lists several categories of things that need to be described in the 3-mile plan. How that is done is really subject to interpretation of the town, what level of detail you want to include. So the 3-mile plan can be extremely detailed, or it can be rather simple and statements related to, for example, proposed location, character, and extent of streets. You could have streets outlined in an area that you're intending to annex or that you would accept for an annexation, or you could just say, have a general statement as to the streets, what the location of the streets would be. So that's just an overview that there are a wide range of 3-mile plans.
And as I was reading through and going through this winter park plan as an example that was sent in, there's certainly a lot, and this is very, as town manager, administrator Miranda Fisher said, this is very generic. First swipe at it, this looks very involved to get to this level of planning and to incorporate. Are we thinking that this is going to be something that will be done by a subcommittee or volunteers or something we might try and incorporate in with the comp plan?
Well, I think it really depends. I mean, just like Miranda said, it could be something that's done with the comp plan. I mean, I think that if you really want to be mindful and thoughtful about tackling this project, I would suggest to do it with the comp plan.
So not really at the level that town and volunteers should
mean,
be
you
responsible
can.
for or not?
Yeah, there's no specific amount of detail that's required. All of the other examples, for example, one of the ones was the city of Centennial, and I think that example was pretty bare bones. So it's required to complete an annexation. So if the town were to get an annexation petition and want to move forward with that annexation, really, you'd have to, if you didn't have a 3 mile plan in place, you'd have to scramble and put one together.
Question about that. Is there anything that stipulates what that has to consist of? Can it literally just be, this is our 3 mile plan, we have no plan? I mean, right?
No,
Okay.
no, but it can be it can be general. It doesn't
General.
have to be specific. And the ones that are specific are typically ones where there are areas. I think the last time we spoke about this, I provided an example. I think it was the town of Dillon that had a 3 mile plan. They had just adopted it. And they know of areas that they have an interest and desire to annex. And there are very detailed maps and descriptions of location of streets, parks, all that for those particular areas.
I think, I mean, one of the things was that Sheila, right, from earlier mentioned was, if we're going to work on a comprehensive plan, we're probably going to bring in consultants. And if we're going to be working on that, we're going to have a lot of public engagement in general with that. Already, we've seen a lot of public engagement with the 3 mile plan and anything related to annexation. So it may be valuable to try to do them both together and leverage the consultants and these public sessions to try to address it. That's my opinion.
Yeah, I would say that, well, we're woefully behind the ball, for whatever reason. So, short of having budget for a consultant, and we need to get started on the comprehensive plan. So one part of what I would say is that, okay, we have a budget, we're gonna get a consulting team to come work with us. In the comprehensive plan, you're gonna have a section on transportation, you're gonna have a section on utilities. You have a section on, future growth. So you have quite a few things that you might be investigating, especially say utilities. Looking at the future, which would just actually then, if you were doing it in the comprehensive plan, then that just becomes part of the 3 mile plan. So you can incorporate your work and your research that you're finding as part of the 3 mile plan. So, and then the 3 mile plan actually is supposed to be part of the comprehensive plan. So I think incorporating them is, considering where we are and what we're looking at, leaves us with not many other options. It leaves us with the best options.
Question for Miranda. Did the recent Board of Trustees budget have some room for consultants?
So the Board of Trustees went for the Energy and Mineral Grant with DOLA for 200,000 for a comprehensive plan, and that is on the high end because we have so many supplemental plans. We have the multimodal transportation plan, the housing plan, the trails master plan. So it actually does leave some good wiggle room for the consultants to work on the 3 mile as a part of the comprehensive plan update.
Okay, thank you.
So we're,
The one thing I would say, Commissioner Rivera, is obviously we don't know if we were awarded funding. And so if it's a 50-50 match, so if DOLA chooses not to fund the comprehensive plan, the board will have to assess funding that on their own. But I feel pretty confident we should be able to secure that funding.
Okay.
so we're still looking for funding for the comprehensive plan.
We're just waiting to find out if we were awarded the energy and mineral. I just submitted that like 2 weeks ago. So I think in the next couple of weeks, we should know if we were awarded half of we said the project was 200,000. So we're just looking for DOLA to fund half.
So Dr. Fisher, I wonder, it sounds like there's going to be a lot of overlap between the 3 mile plan and the annexation plan. A lot of the information for the annexation plan would need to be in the 3 mile plan as well. Is that correct? And is that something that we have I thought we had a timeline before the super IGA expired that we had to come up with at least a 3 mile plan and possibly an annexation plan.
Well, so to Attorney Madsen's point, I guess I'm not familiar with an annexation plan separate from the 3 mile, but the 3 mile would have to be in place before the town could evaluate an application for annexation. But Attorney Madsen, do you have more to add?
Yeah, so I'm a little bit confused on the question about the annexation plan.
In the ordinance?
Or annexation ordinance that we would have to adopt before we could, once the IGA expires, before we can consider that. I thought that the public meeting we went to at the library that they talked about that it would be required to have, a 3 mile plan in addition to an annexation. I guess annexation ordinance is the right word for it.
So the Board of Trustees adopted the annexation ordinance in December, and that is in effect. And that is pretty thorough as far as the requirements on an applicant, petitioner to annex into the town. Separate from the requirements, well, the ordinance is in addition to the Annexation Act, which is in Colorado state statutes. And in the Annexation Act, there is a requirement to have the 3 mile plan in place before the Board of Trustees can approve an annexation. So it doesn't mean that if there is no 3 mile plan in place, that doesn't mean an annexation petition couldn't be submitted. It would just have to be a hurry rush type of thing to get it together if that was a project that the town wanted to annex.
Okay, I'm just conflating a couple of things then.
And pardon my ignorance, but the whole reason the 3 mile plan is the sudden issue is because we do not have the IGA with the county anymore. Is that correct? Or am I missing something?
We don't have the IGA between the town of Nederland and Boulder County. That IGA expired at the end of December.
Right. And previously that sort of governed our annexation policy such that we didn't need this 3 mile plan.
Well, I mean, I think that if there were to be an annexation under the IGA, under the IGA with Boulder County, you'd still have to have a 3
We
mile
would have been
plan.
scrambling the
Yeah.
same way.
Yes.
Gotcha. So it's just kind of a step in the process that we hadn't really talked about previously.
Right.
Gotcha. Thank you.
I think, Tim, we definitely, we dropped the ball a little bit. Certainly at the comp plan 10 years ago, it was a look that infill was looking the end. So there actually is development plan there as you look at it, but it's the town limits and where development going to town limits. So I think from that discussion, that thought and the IGA being there, that somehow, just until last fall or summer when I saw this thing about the 3 Mile Plan. I'd almost forgotten about it. I had to look it up and try to, bring it to attention and get at it again. But it was something that I don't know that I've heard that word in planning for 4 or 5 years here in town.
And then, so like the 3 Mile Plan in its very vague general sense right now, there's no requirements in terms of a parcel needing to be adjacent to the current municipality or meet any other requirements like in previous language we had in our annexation ordinance. It's talking about, no less than 1/6 of the perimeter of the area has to be contiguous with the town and all these other requirements. But as it stands now, we could annex a mining claim parcel clear up almost to the divide.
No. So the contiguity requirement which is the adjacency requirement to the town boundary still exists. That's under state statute, that's under the Constitution. That still exists. So you still have to have the 1/6 contiguity with the boundary of the annexed parcel of land with the town.
Gotcha. So we couldn't annex like these islands of Nederland that are, even if they're 200 meters beyond the boundary.
No, there's a way, there's annexations and they're called flagpole annexations. And they can be done by annexing parcels of land so that you have a parcel that's 1/6 and that's a small parcel, and the boundary of that is 1/6 contiguity to the town. And then essentially, basically, you keep growing the parcel, and that's what the flagpole is. But you still meet the 1/6 contiguity.
And you have to start with being adjacent
Yes.
to the town.
Yes.
Yeah, gotcha. Cool, that makes sense and answers my question. Thank you.
Okay, at this time,
Sorry, one last thing. So if we do look at the path of working on the comp plan with the 3 Mile Plan together, using consultants, from what we learned earlier, this all seems like it would come on our committee. Would we be engaging and including members of other committees or the Board of Trustees, or is this something that we would be taking on just on us? Now, I guess it's a question for Miranda.
I mean, I think that could be decided by the planning commission,
Okay.
who you feel like would be appropriate to be involved. Though I would say the one thing about kind of the bare bones that we put together is, of course, taking a little bit from Centennial, we reference a lot of different plans. Like if you're looking at, proposed annexation of recreational assets, then of course it's going to be important to have ProSab. So I think a lot of that is the conversation too, is like what areas do we want to look at? What things are we considering? If we're considering annexations, is it just parcels for housing development, or are we looking at expanding, say, recreational assets?
Okay, thank you.
Okay, at this time, we'd like to open this up to public comment. Let's start with in the room here. If you would like to step forward and identify yourself, you will have 3 minutes.
Kayla Evans, 1250 Eldora Road. I appreciate a qualification from the town's attorney. You said the 3 mile boundary for annexation is a state statute. Did the town of Nederland currently have that, or does or is this something municipalities are working on adapting?
I'm not sure I understand what the question is.
Did Nederland have that, or are we trying to adapt it?
There is no 3 Mile Plan in place.
Even though it's a state statute, we didn't have one.
Right.
Why not?
I don't know the answer to that question.
Okay.
Roger said we dropped the ball, so.
Okay, all right. The map, the little protractor that we drew around the town, is the 3 mile from the border out, Or is it from the center? How are they determining?
The statute requires 3 miles from the boundary.
From each boundary.
Yes.
So it really shouldn't be a round circle like that. It should be.
In the shape of Nederland.
Yeah.
Well, okay. Then my other comment would be, I know that there are a lot of people who you say the word annexation to them and they just go crazy. So when you have a circle drawn like this around the town of Nederland, and now Eldora is included in it, and a lot of areas where people are outside of town, they're going to think that they are able to be annexed. That's not going to happen. And I think color coding that circle to show private property, property that's under conservation easements, Forest Service property, and areas that really, because right now, if you just looked at that map, you'd go, holy shit, I can be annexed and I don't want to be, and I'm within the boundaries, and someday it's going to happen. It's not going to happen. But that information does not present itself in that map. So to alleviate the stress and the fear and the misunderstanding from a lot of people, I think that would be a helpful tool to just make that map a little bit more informational than just whoop, we're in the 3 mile area. So thank you.
Okay.
And you will be hearing from me about annexation.
Thank you for that comment, Kayla. And again, for those listening online, this is a first draft, and it was just, I think, so we had some kind of visual representation. This will change a lot. Okay, if you are online and you would like to comment, please, if you have to call in, start working on that now. And otherwise, identify yourself and name and address, and you will have 3 minutes. Anyone online that would like to comment? All right, going once. All right, no public comment from online. We'll bring it back, close the public comment portion and bring it back to the room. Any other discussion from the Planning Commission on this issue?
Well, I would just want to say, because what Kayla said is probably true, because it's happened several times whenever the word annexation comes up. You know, we've had people all the way from, you know, Caribou and Ridge Road especially. Maybe we ought to just either eliminate that map or just say this is a hypothetical illustration until we actually start working on the map. Because the idea, which is, Kayla's exactly right, to actually make a 3 mile plan with all those things, you know, that could actually take quite a while to make that map. That would actually be the 3 mile plan map, or the comprehensive future map would actually be quite a bit of work and actually could be a year or 2 away. So, you know, we actually ought to just label this as just a hypothetical illustration. So it's very, very clear that we're not looking at annexing these parcels, but anything out there. And we certainly, that was the first thing I looked at. I said, well, we're not going to annex property in Gilpin County, was the biggest one that kind of struck me. But that was just an idea. I mean, that's what I think, you know, that would be important.
I was gonna make a joke, but I'm not gonna do it because someone is gonna take it wrong. I agree that I don't know what the answer is. You know, it's lucky that we have people that are in our community that are invested enough that they dig up the packet and look at it. And the first time they see something, they post it on Facebook and people start wanting to know, oh my goodness, what's going to happen? I don't know what the answer to that is because we want public engagement. Britt and I talked yesterday about giant 4-inch wide diagonal watermarks that say draft across each page. I don't know how possible that is, But all we can continue to do is educate the public that, one, the town is not coming for your property. And two, any property that gets annexed has to be initiated by the property owners, not the town, not the trustees, not the planning commission. So as long as you have a good relationship with your neighbors that border the town, I don't think you have anything to worry about. You know, that's my take on it. Am I incorrect, Dr. Fisher? No, she has no comment. All right. please-
Very good comments, Jim. I think you're exactly right.
Okay, with that then, the questions before the board are, let's see. I can't find it on my computer right now. Could you tell us what those are?
Oh, I was muted. One of my questions, I think, before the board, and it's not really here, just is like, what recommendations do you have? And one of those recommendations could be to encourage or to have the consultants under the comprehensive plan take on the 3 mile plan versus it being done separately, or it could be let's keep working on it kind of more administratively. There is, and Attorney Madsen had, and I'll add this too. So when we filed for the comprehensive plan, we did acknowledge that a part of the comprehensive plan would be a kind of an incorporation, of course, of the 3 mile plan. You know, I didn't necessarily interpret that as meaning the whole thing had to happen under the comprehensive plan, but I'm also not opposed to that whatsoever. I just knew there was desire from the Board of Trustees and the Planning Commission to at least just get this conversation started.
Okay, well, I agree with that, and I think there's, you know, some preliminary work we can do, but if we want it to be as in depth as some of our public comment emails were, I think it probably the best course of action would be to try and incorporate this with the comp plan where we could have some professionals leading this, you know, probably going to have to set up, I don't know, 5, 8, you know, public listening sessions. We're going to have to, I mean, it's going to be involved. And I think it's a lot to ask even a subcommittee of this board, which are all town volunteers, to try and town staff. It's a lot of work for you guys. Most of it falls on you guys because you have to set it all up and write it all up. I think you guys are pretty busy. So probably would be great if you can, you know, contract that out to another source and somebody who their expertise is, you know, they're a subject matter expert. This is what I do for a living, is develop comp plans and lead these public meetings. And as Chris said earlier, if we can find the person who can come in and help us have these conversations without conflict, man, and that would be awesome. Because I haven't seen the person in our town who can do it so far. I certainly am in agreement. Any feedback from the rest of the planning commission on that?
I'm in agreement as well. Timeline wise, how far out are we from having a comprehensive plan? I mean, an updated one, of course.
Dr. Fisher?
We're a couple of years, I'm guessing.
Yeah, I mean, I've awarded the funding, you know, I did have it set, you know, a year plus process. So I'm not sure we would be ready to adopt a new comprehensive plan until the end of 2024. And that's assuming, of course, we can even get started this summer. I think you're looking at end of 2024, 2025, because it is such a long, in-depth process.
Are there consequences to waiting that long to have a 3 mile plan in place?
Well, the real question is, do we have anybody who we know or think wants to get annexed?
Right.
In the near future.
So we do not have an active application, but we are aware of potentially one pending. And yes, that would play into this, of course.
So the consequences, we can't annex anybody
Right.
who is requesting to be
Yeah.
annexed into town. Again, along with my recommendation that this be done professionally, because I just think in our community, man, you got a lot of strong opinions and people want to come out and have their say. And I just think it's a lot to ask for you guys as a town staff and for us as volunteers to try and corral all those things. Professional facilitators that do this for a living would be much better suited. And I'd rather have it done right. If the BOT says, man, we got to have some kind of 3 mile plan, I'm sure we could put together something. We can get a subcommittee together and do a first draft at it, but it would have to know, well, even if it's an incomplete plan, then you would have people then in the public that are concerned. So I almost worry that we should probably wait and try and get a good professional product, then put something together that then has the public up in arms. In addition to that, I would recommend some kind of a public information campaign from our public engagement manager on staff now on Facebook and maybe in the paper with some frequently asked questions answered about annexation. Man, I mean, the best thing we could do is start getting information out there about how annexation happens. And, you know, hey, am I about to be annexed? No, not unless you ask it. You know, something that we can kind of calm the waters, because I'm telling you, people know I'm on the planning commission, and they come up to me in church. They come up to me at the grocery store. They come up to me at the post office, and they're concerned. They're very concerned that there's a land grab and developers are going to jump in, and we're going to have Breckenridge housing out there, you know, somewhere on Sugarloaf or something. I don't know, but okay. Other feedback? We can close this item.
I guess the only other question is, if we know there is one that could possibly come up, Attorney Madsen, I mean, we can't just deny it because we're not prepared, right? How would that work?
Well, an annexation is a legislative decision. So really it can be denied if the Board of Trustees ultimately determines that it doesn't want to include this area within the town boundaries. So that's always an option on annexation. It's ultimately a Board of Trustee legislative decision as to whether to take on new property. You know, another thing that I was thinking of is the annexation application that comes to the town that may have some of the detail that is needed for a 3-mile plan. So if there was an interest to move forward with a particular project, move forward with an annexation, maybe the information in the application material that's submitted would lay out detail that is required by the 3-mile plan. And so then a 3-mile plan could easily be converted based on that documentation. It's just
as a stopgap, if an application, if somebody
exactly.
wanted
I mean, it's not the same thing as having a professional planner do it, but state law doesn't require a certain level of specificity. Doesn't require a professional planner. It requires discussion of those items, but again, the detail is not specified.
And of course, what you say, Jim, there would be no pushback. So yes, I think it's a tough decision of which way to go there.
Okay. Anything else you need from us, Dr. Fisher? You're
Sorry, I'm muted. I guess I'm just wondering, what is the official recommendation of the planning commission? Am I gathering that it's let the comprehensive plan unfold unless an annexation application comes forward and then we'll deal with it then? Is there a desire for a smaller group to keep at least just talking about this more? I think that's what I'm looking for.
Yeah, I mean, my opinion is if we keep talking about it, we keep trying to work on new maps and these kind of things, the public gets wind of it, it's going to snowball. I think bringing it together and working on it with some consultants and having the public engagement, approaching it, then taking our time, taking a year, I think that's a good approach. And we have a stopgap if we need to, if we get one. That's my opinion.
Yep. I agree. I mean, I think the development of a 3-mile plan is beyond any of our skill or expertise, and we need consultants. And given that there's no source of funding outside of the comprehensive plan, if I understood correctly, I think that has to answer the question.
Yeah, I mean, if we don't end up with this grant and we have a problem with budget, then we're going to have a different conversation, and we can talk about that next month and see, okay, maybe we do make a subcommittee and at least work with some, like whoever was working on your GIS map and try to look at, something more basic to come up with. But Let's see if we get this funding first, I think.
It seems logical to me that any discussion of a 3 mile plan would sort of be in conjunction with the comprehensive plan update that we need to do. Otherwise, we'd be kind of potentially backtracking and like working against ourselves because, oh, well, we want this, but we set this up last year. So now we got to update this to accommodate that. It would just make sense to kind of do it all together under the same pretense, I think.
Okay, go ahead, please.
Well, I mean, I think I repeat myself, but exactly and many of the elements of the comprehensive plan are part of the 3 mile plan.
Yeah, there's a lot of overlap.
And
That's where I was getting confused earlier. Thank you.
I think just with I mean, it just seems like, as being not a trustee, but a trustee of the situation, that you just, in the atmosphere of the town and the word annexation, that I think that throws it over the top too, that we have to just do this right and do it right professionally and correctly the first time so that you're above a challenge. So that's, I guess that's the deciding factor. There certainly are some things we could work on, but let's just see how quickly we could even get an answer on the funding, and then it might not be, the ball might get rolling quicker than we think. So hopefully that works. So.
Yeah, and Miranda, can you keep us updated on that through email?
Oh, okay. Well, I think we have a consensus here that we would like to, if possible, have that done in conjunction with the comprehensive plan. And I think that the reasons to tell the BOT we're recommending that is public concern as we attempt these, with volunteers, that the backlash might not be worth trying to get something out. I know I've seen some feedback from the BOT that they want something, they'd like to get something, but I'd rather have a better plan. And then if we do get an application and we need to address it, then we would certainly be willing to take it up. Maybe it would end up being a subcommittee effort, and it wouldn't be a complete, plan that we would end up with through the comp plan process, but we could come up with something that would work for that potential annexation application that would meet the requirements. But certainly, all the things that were brought up in the public comment about, water and sewer load and road networks and all those things, are a lot of work, a lot of stuff for town staff and for volunteers. So our recommendation would be to go that way. And then we'll see what the BOT says that they would like. And if they have some other strong feelings, I'm sure you'll let us know.
Yep. Sounds good.
They'll probably let us know too. Okay, then any other issues with this item, Dr. Fisher?
Nope.
Okay, well, let's move on to the last item on the agenda, the staff report, and I will leave it to whoever is presenting that to make it as brief or as involved as you would like.
Yeah, so I'm switching it up on you all. I'm just throwing every staff report into your packet versus me trying to summarize it. And I just want to hit the super big highlights for each. So first, just kind of the acknowledgement celebration of staff is that we did our first ever town hosted event called Netter Days. And I just wanted to acknowledge the parks team and Peter for all the work that they put into preparing that event. Couple of other things. So I'm currently conference-wise, I'm currently at the Colorado City and County Management Association conference, or I would be there in the room with you. I attended that, and then Britt actually recently attended the Downtown Colorado Inc., and they handle kind of downtown development. So we're all getting our education on. Couple fun grant things. The town received our tourism management grant, which gives us $20,000 to work on kind of brand identity and visitor education. So get started on that. Big Springs egress closed, and we are evaluating the requests for proposals that were received. And so we hope to get moving on that. We released the multimodal transportation plan RFP and are asking for submissions by mid-May. So that's also moving. And the really exciting emails today and yesterday, I was notified that both Senator Hickenlooper and Senator Bennett have picked up the secondary bridge funding as their priorities for congressionally directed spending. No guarantee, but I'd like to think that two senators identifying it as a top project is a good sign. So we'll find out August, September if we were awarded, and we're asking for about 2.8 million for that project. So we'll see what happens there. Send good thoughts. Housing needs assessment. We've gotten really low turnout about this, and we're actually going to talk about it with the Board of Trustees. Only 29 people have really participated actively in the surveys or attended the workshop, and so we're still looking for feedback. So if the Planning Commission hasn't done the interactive map or the community survey, we would ask that you do so and give us feedback about housing. Brit is also handling a broadband speed test. We're trying to understand how fast or slow your respective internet is. And so we ask that you run a speed test and send the results to Brit. I'm just going to skip. You can look at the financials when you get a chance. Many of you may know or you may not. So Troy Hendricks was our police and court clerk. Obviously, with the change with going to Boulder County Sheriff's Office, we really didn't want to lose Troy and all of his knowledge. And so he has moved into an emergency administrator role, and he is working on emergency operations plans. He'll start to work on developing evacuation routes for the respective neighborhoods out of Nederland with the sergeant and the fire department. And just as now, all things emergency management. So really glad to have him in that role. Troy has over 20 years experience in law enforcement, and so he's perfect to assist us with our emergency planning. Parks Department is ramping up. They are getting ready to do town cleanup. That's Saturday the 3rd. So if you're interested in volunteering, let us know. They're also doing Barker Meadow Park GoCo Grant volunteer days, and that's in the packet of what days to sign up for. Streets team, of course, once the weather gets better, they will start ramping up on culvert, grading, drainage work, and they actually recently acquired 3 new pieces of large equipment, which will make it easier for them to do that work, and that equipment is set to arrive in about 2 weeks. Utilities, also busy as the weather gets warmer, and I think one big thing for everyone to be aware of is hydrant flushing. That can lead to discoloration of water. We'll do a lot of social media posts, but be ready for that. The other really exciting thing is we're actually working on an ordinance that would remove the fee for a meter replacement. We estimate over 100 accounts a quarter. So it's really important for us to go out and fix these faulty meters. Previously, a homeowner had to pay somewhere between $150 and $200 for this. We have decided to remove that fee and credit anyone who paid for a meter this year or last year. So that's a great thing that Andrew has done as the utility supervisor, just to try to get people to want to replace their meter and not have that financial expense. Otherwise, there's a lot going on with solar. There's a ton of updates in here from Leah about the solar work she's doing. And then, of course, Peter is starting to step into his role as an public engagement manager. And one of those platforms that's coming is called Engagement HQ, which is a portal where you can click on and get updates on any project that we are working on. And I think that's the report. Those are the highlights in a nutshell.
All right, that's excellent. Britt, could you send out those 2 links in an email again for those surveys you'd like us to do?
Absolutely.
Yeah, and I will say that with the weather, maybe that was part of what keeps everybody hunkers down a little bit. It's been a cold winter. Maybe we can try and have. I missed it. I missed the whole. I saw something briefly about the housing needs study, but then life got in the way and I missed out. So maybe try and re-engage the community on that as things warm up, and we'll have some better luck.
Yeah, that's what we're going to talk about it with the board. Is there's not enough data to feel like we can really move forward. And so what's the best way to, our consultant dollars only stretch so far. So what's the best way to try to re-engage the community? Because we still have until the end of the year to finish it. So it's not like we're out of time. We just need to get the engagement up.
Okay, thank you. I hope you have a good time at your conference. And if you see my wife, say hello.
I've already seen your lovely wife. She was a panelist this morning. So It was delightful.
I would entertain a motion.
Make a motion to adjourn.
Second,
Second.
all in favor? Or I'm sorry, I can't call that. Go ahead.
All in favor?
Aye.
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 All right, meeting adjourned.
Goodbye. Thank you.
Thank you.